May, may I please, Lordship? I beg to mention item number 7 and 8. In item 8, Lordship, we were supposed to file an affidavit. Lordship, the authority has asked for some more time. Lordship may take it up any date after next week, Lord. It is
Lordship, I am for the
affidavit.
petitioner in this matter, Lordship. Lordship may kindly take up this matter on 26th of March, Lordship, subject to convenience.
Okay, as agreed by learned advocates of both the parties, raises and lays the matter on 26. Okay,
Obliged.
deeply obliged.
May I please, your Lordship?
Yes,
Lordship, I beg to mention item number 28, my lord. In this case, my lord, earlier, my lord, Lordship observed that the last date was 10 fixed. And on that day, my lord, the matter was fixed for disposal. But unfortunately, on 10, my lord, matter has not been reached, my lord. If possible, my lord, will be taken up during the course of the day, my lord, at 2, after 2, my lord.
no special preference. We'll call the matter, and if possible, we will try to dispose it.
Obliged.
Make the pleases, your lordship.
Mm.
Taking concern of the other side, your lordship, I beg to mention item number 9 of the daily list. Your lordship, here kindly grant us 2 weeks' times, your lordship, further. I've taken consent from the other side.
Lordship, date may be fixed, Lordship, it's 2020 matter.
Okay, on the pairing made by Ms. Pidas, learned counsel for the respondent authorities, with consent from the other side, this is lays the matter.
On 25, Lordship.
2 weeks' time. will be-
First week of April.
First week of April.
3rd April.
Interim order is there, Lordship.
Interim order shall continue.
3rd April.
I'm deeply obliged.
May I please,
3rd
Lordship?
April.
I beg to mention item 41, Lordship, as a hearing matter. So in this case, we have filed one additional affidavit. It is not in the record. So may I pray let the matter be adjourned for a week?
Matter
Adjourned for a week.
for a week.
Lordship.
Go for the petition.
I'm for the petition.
Your good name, please.
H. Shetty, Lordship.
On the pairing made by Mr. A. Satre, learned counsel for the petitioner. You inform the other side.
Yes, the
With
education
consent from the
department.
other side.
Okay.
As for listing the matter after a week, pair.
Obliged, Lordship.
May I please, Lordship? Lordship, I beg to be cited by 42, Lordship. It is a criminal, Lordship.
Yes,
I have taken consent from the other side, Lordship. Lordship, maybe 42. It is criminal matter. It may be taken after 2 weeks, Lordship. I have taken consent, Lordship.
on the pairing made by Mr. Ashok, learned counsel for the response number 1. With consent from the other side, this is list the matter after 2 weeks.
Please, Lordship.
Okay.
May I please, Lordship? Lordship, I beg to mention for listing, Lordship. Today, unlisted, Lordship. It's an urgent matter, Lordship. It's a transfer matter, Lordship. Today is the last day for joining, Lordship.
No. Today not possible. You see the list. How many cases fixed today?
Yes, Lord, as a last item, Lordship, because 11/3
No, on Monday.
Monday, today is the last for.
Who is responsible for filing a bill so belatedly?
That's true, Lordship.
Then? Okay, as last item, we will try.
Lordship.
If possible, we will take it up. Otherwise, Monday.
Before court.
Obliged, Lordship.
Yes,
My item number 47, I filed affidavit yesterday, affidavit in reply. So the report is not-
47.
47. So report is not added, so kindly call for the report.
Pardon?
Call for the report.
Okay.
May I please, Lordship? Lordship, I beg to mention item number 52 with the consent of other side, Lordship. 52 of supplementary list, Lord.
Yes.
Lordship, in this matter, what happened?
You are for?
I am for the petitioner on behalf of Mr. S. Samaria, Lordship.
Miss, your good name?
MM Jamal, Lordship.
Learned counsel appearing on behalf of Mr. S. Learned conducting counsel for the petitioner. With consent from the other side. This is the matter. This is part-third matter.
Lordship, thing is that, Lordship, this matter was listed day before yesterday. The other side mentioned it without our consent, Lordship, and fix it today. So some difficulty is there today, Lordship.
What difficult?
There are a lot of cash, Lordship, which are fixed today, and Mr. Samaria have to appear those cash. They mention it without our consent and fix it today, Lordship.
When to be listed?
After 2 weeks, Lordship.
After 2 weeks. The matter is then released from the partner. Okay, yes,
After
Ma'am,
3 weeks.
with regard to item number
3 weeks.
4, my lord.
no, not CV, part thirty.
After 3
Part
weeks.
My lord, item number 4, my lord. No, we seek some more time to seek instruction, my lord, as the vice chancellor of the university is out of station, my lord.
Lordship,
So, matter will come after 10 days, my lord.
Lordship is an urgent matter, it's a part hard matter where the results are awaited. Therefore, otherwise, we are within the rules, we are within the permitted chances, just they were told to bring instruction whether university can give the results. So they sought some time for taking instructions, the university.
Well, university today, vice chancellor is not there, my lord. 1 week or 10 days, my lord, time, my lord.
So 1 week then.
Yes.
Mr. Your good name?
VK Borua, my lord.
PK Borua, learned counsel appearing on behalf of
Borland University, my lord.
your standing counsel.
I'm not a standing counsel, my lord. My senior is my standing counsel.
You are appearing on behalf of
Borland University, my lord. Respondent Borland.
KK Day, Lordship. KK Day.
On behalf of KK Day, my lord.
on behalf of Mr. KK Day, learned conducting counsel for the defendant. With consent from the other side, recessal is the matter suggested.
Lordship, any date is convenient to your Lordship.
Hello, bless you.
Deeply. Please, your Lordship.
Yes.
Lordship, I'd like to mention item number 34 of the daily list. Due to some difficulties, my senior could not come today.
Item
Item
34, you are for petitioner or respondent?
Petitioner,
Petitioner, your name?
MJ Bharali, on behalf of N. Bora.
Mr. So-and-so, learned counsel appearing on behalf of Mr. N. Bora, learned conducting counsel for the petitioner with consent from the other side, by for listing the matter after
2 weeks.
May I please, your lordship. I beg to mention listing of 3 matters, my lord, admission matters. First last listed long back, my lord. Next week, any date you have.
Take a date from him.
Lordship, in item 52, there is an interim order that may be continued also. I have just mentioned, Lordship.
Okay, interim order passed earlier, shall continue.
52.
No. May I please, your Lordship? Lordship, praying for listing of the 2 WPC matters which was listed on last year, my lord. Any date may be given in a motion column, my lord.
Take a date from him.
Oblige, your Lordship. For that.
May I beg to mention this, Lordship, this case has not been listed since to 28/10/2024, 24/2022, which has to be listed urgency on a very urgent basis.
Whether, since when it has not been listed?
28/10/2024.
24.
Yes.
When do we want?
Next week, maybe, Lordship.
Yeah.
Urgency, 21st. Thank you.
Please, lordship. I may be allowed to withdraw this petition with a liberty to file this, lordship.
Yes. Mr. M.
M.
H. Borbuya,
Hussain, lordship.
M. Hussein, learned counsel for the petitioner, submits that he has the instruction to withdraw this petition. And he may be granted liberty to approach this court again by filing appropriate petition. Where is allowed, this WPC instance dispose of on withdraw. However, liberty will remain with the petitioner to approach this court again by filing appropriate petition.
My please, your Lordship. Lordship, in this case, charges submitted, your Lordship. I have a certified copy, your Lordship.
Charges submitted.
Charges submitted, your Lordship.
When?
Yeah, 20 February, your Lordship. In front page, it is mentioned as 12 February, your Lordship. There is a difference of date, your Lordship. I have given a copy to my friend, your Lordship. Earlier, 12 February, your Lordship, status report was called for, your Lordship.
No, whether it was submitted within the stipulated period of 60 days?
No, 67 days, your Lordship. If it is considered 20 February, then 67 days, your Lordship. In last page, your Lordship, charge sheet, date is given, your Lordship. Last page. At bottom, your Lordship, 20 February of 25. But in front page, your Lordship, it is given Point number two, 12 February, Your Lordship. If 12 February, 59 days, in 20 February, then 67 days. Your Lordship. It is 20 February.
When this petition was filed before this court?
Lordship, on 7 February, Your Lordship. Earlier, 7 February and on 12 February, it was listed for motion, status reports were called for. On 21 February, Your Lordship, it is listed wrongness, Your Lordship. Before charge sheet, Your Lordship, I filed this case. Status report call for. Mandatory one, 50 rupees. 59 days.
Yes, Mr. Das?
Lordship, if we look into the first place, Lordship, point number two, it is dated 12/2/2025, Lordship. On that day, it would be 60 days,
No, 59 days.
59 days,
59 days.
12/2/25.
And if considered 20, then 67 days. Your Lordship. And it is seen by the learned court on 27 February. Your Lordship. Top of the page, Your Lordship. Date. February is a wrong date. Your Lordship.
It is stated in the point number two, Lord.
Mr. Das, find out the relevant case law
Lord,
regarding default bail
Lord,
and also obtain instruction from the IO
I need
concerned
to
on
obtain
which that he actually filed a.
Lord, I'll take instruct.
Can
I
you
will take instruct.
fix at 2 PM, Your Lordship? 2 PM.
Then you go to the trial court. If there is so urgency.
Then Monday, Your Lordship, another case is going to pending, Your Lordship. Item number,
Monday you obtain.
item number 15, Your Lordship. Daily list 17/3, Your Lordship.
Heard Mr. Corey, learned counsel for the petition. And Mr. K. Das, learned additional PP for the execution. Mr. Corey, learned counsel for the accused summons that. In the meantime, the IU has completed investigation and submitted search sheet. And as per the date mentioned in the column number 2 of the search sheet, it is 12/2/2025 on which the search sheet was submitted, and as per the last page of the search sheet, the date is mentioned as 20/2/2025. In the day of the matter, Mr. Das learned that additional PP is directed to obtain necessary instruction as to on which date the IU has filed the search sheet. This is the matter.
Seventeen. Lordship, item 30 similar prayer, Your Lordship, today list, Your Lordship. out of same case diary, Your Lordship, same PS, 30.
No, this search sheet is submitted, if search sheet is submitted,
Item 30, similar PS, case number 30,
no, this is
to the
AB.
list.
It will not.
98. এই হোক, তার সাথে একটু আগত করা আছে। কিছু কিছু কিছু।
Same order in item 13.
Obliged, Your Lordship.
I did also the second bill application, Lordship. Earlier also, there, Lordship. Let us call for the updated case, there, Lordship. Case state is that.
Mr. Detka, learned counsel for the applicant, and Mr. Kiketas, learned additional opinion for the state responsibility. This application under section 482 of the VNSS 2023 is preferred by this. Preferred by applicant Rafiqul Hussain Kuya, Rafiul Hussain Kuya, and Sofiul Hussain Kuya, who have been apprehending arrest in connection with narcotic case number 72 of 2024, registered under section 303, bracket 2, 317, 325, 612, VNS with section 13 of the Assam Cattle Preservation Act 2020. The learned counsel for the applicant submits that this is the second pre-arrest bail application prepared by the applicant. And the first one was dismissed by this court after perusing the case diary by order dated. Where is that order?
Order is not.
Uh, 27/1/2025. What is the ground for filing this second application?
Lordship,
What is the ground?
New Lordship, he is a businessman, Lordship. He is in a division, in that vicinity, he is a businessman. He is being harassed by the other business rivals, Lordship. That is the New Lordship. And
Having heard the submission of learned counsel for both the parties, it is provided as Mr. Das learned additional petition for the case there before this court on
20.
obliged.
Kindly peruse my lord, order dated 6/3, my lord. The directed, my lord, the receive instruction from the director of pension, my lord.
We have received a letter from the district elementary education officer Kokrajhar, seeking the return of original service book and all pension papers. We are under process, now. We'll return it to the concerned department shortly.
Annexure 29, my lord. Original service book and pension proposal submitted to the director of pension, my lord, for final sanction, my lord. And subsequently, my lord, it is stated that, my lord, the matter again remand back to the, my lord, the DO, my lord, for some defect, my lord. And on last occasion, my lord, the standing council BTC submits that, my lord,
On the basis of this letter, my lord, we are undertaking to return the files, pension papers and the original service book. Shortly, man. Yeah, no.
issue notice, my lord. It is a motion state, my lord. And pendency shall not be a bar, my lord.
And whether it is returned,
Not yet, my lord. We are undergoing, and shortly we will send it, my lord. So in the meantime, my lord, let notice go, my lord. In the meantime, we will return it back.
heard Mr. K.R. Patil, learned counsel for the petitioner, and Mr. G. Pegu, learned additional senior government advocate for the respondent number 2,
2 and 5.
2 and 5. And Madam for,
I am appearing for 6, 7.
that Ms.
7 and 8.
R.B. Bora, learned counsel for the respondent number 6, 7, and 8.
9, 10, 10 to
And who is for elementary education department? Mr. Pegu. For respondent number 1 and 4. Then finance department, Mr. Barposari for respondent number 3 and 9. Mr. Padgiri, learned counsel for the petitioner, submits that. In this petition, notice is yet to be issued to the respondents. Then as such, notice may be issued to the respondent. Then further submits that necessary order may be passed so that the pendency of this petition should not be a bar in granting the reliefs as tried for by the petitioner in this petition. Whereas taking note of the submission of learned advocates of both the parties, it is provided that notice be issued to the respondent authorities returnable on when
4 weeks, my lord.
4 weeks.
My lord.
Returnable in 4 weeks. However, no formal notice is required to be issued as all the respondents are represented by their standing counsel.
Respondent number 10 has to go
At
by
this stage, not, it is not required, my lord, headmaster.
Respondent number 10.
At this stage, not required, my lord. Because, my lord, the pension people already submitted, my lord, to the DO, my lord. Headmaster, my lord.
Except respondent number 10. Mr. Padgiri submits that this pension paper has already been submitted to the
District Elementary Education Officer.
District Elementary Education Officer.
Kokrajal. Respondent number 7.
No notice is required to be issued to the respondent number 10 at this instance. Accordingly, issuance of notice to the respondent number 10 stands dispensed with for time being. Further, Mr. Pegu, learned standing counsel. So who was directed to obtain necessary instruction?
Government advocate Assam.
Mr. Pegu has obtained necessary instruction pursuant to order of this court dated 6/3/2025 and submits that the service book, original service book and pension papers will be returning to the district elementary education officer within a short period and price for listing the matter after 4 weeks. There alone, SSL lets the matter after 4 weeks.
The petitioner is a student of MBBS first year, lordship, of Nagaon Medical College, lordship. After what had happened, an FIR has been lodged. May I submit, Lordship? The petitioner is a student of MBBS first year of Nagaon Medical College and Hospital, Lordship. So what had happened, Lordship, an FIR was lodged on 10/1/2025, Lordship. But the petitioner was not named in the FIR, Lordship. Thereafter, what had happened, Lordship, he was subsequently arrested by the police, Lordship. And on 13/1/2025, Lordship, the petitioner was expelled for a period of 6 months, Lordship. Impugn order is at page, Lordship, 24 of the writ petition, Lordship. Annexure D, Lordship. Annexure D, page 24, Lordship.
Yes.
Office order in pursuance of the memo number Nagaon so-and-so submitted by so-and-so Enquiry Committee on the involvement of medical students in the act of theft of valuable materials from the Central Library and MCH Nagaon, the following office orders are hereby issued. One, Muhammad Asik, Lordship, that is the petitioner, are hereby expelled from the NMCH Nagaon for a period of 6 months. Two, both the above mentioned students are hereby debarred from entering the hostel premises during the aforesaid period, Lordship. So, Lordship, FIR was lodged on 10th, Lordship, and 13th, Lordship. They have issued this order, Lordship. And in the order, there was no specific statement regarding the procedure adopted by them, as well as no hearing was conducted. In fact, on third day of lodging the FIR, the said order has been passed, Lordship. And charge sheet already submitted in this case, Lordship. And if trial is yet to commence, Lordship, if the petitioner is acquitted during the course of trial, Lordship, his 6 months will be 6 months from his academic career will be gone, Lordship. On the last occasion, Lordship, instructions were sought for, Lordship.
First of all, my lord, the petitioner named in the FIR, Lordship, may kindly see. Inadvertently, my lord, instead of Asif, Asif has been mentioned. He is the same person, and in fact, he has been arrested, he has been searched. Otherwise, also supposedly his name is not there. But during investigation, it has been found that he was involved in the stealing of, my lord, computer CPUs from the college and valuable materials from the library. They were caught red-handed, both the petitioner and another person, student. They have been caught red-handed by the security guards. And my lord, search sheet has been submitted. That's why this action has been taken by the authorities. A student, my lord, medical student, my lord. He was stealing, my lord, CPU from the, my lord, college. 7 CPUs, along with one, my lord, second year student. And they have been caught red-handed by the security guards. Now, while lodging the FIR, inadvertently, instead of Asif has been, my lord, mentioned. Lordship, you will see the photographs, my lord, in the forwarding report. His identity card is at page, my lord, 15. And Lordship will see the forwarding report at page 23. 15 and 23. The middle one, my lord, in the page 23 is the petitioner. And my lord, page 15, the I-card is. 15 and my lord 20.
15 and
23. It is part of the my lord forwarding report of arrest.
Lordship, I am not denying the fact that I was arrested.
And lordship will see the date of forwarding report, 11/1, FIR on 10/1, so they were arrested on that day itself. Because they were caught red-handed, on 11/1, they were produced before the court, my lord, trial court, for production. So, my lord, Asif or Arif, whatever is mentioned, my lord, that doesn't matter now, my lord, he has been succeeded. So it's proved that he was involved, he is the only person, my lord, and along with another. So that cannot be a ground, my lord, for filing a repetition and challenging this, my lord, order of suspension. And it's, my lord, he is lucky that he has not been expelled for, my lord, entire his admission has not been cancelled. He has been expelled for only 6 months. And lordship will see. And on top of that, my lord, I have given a bunch.
Hmm.
I will not file it in the affidavit, but in the form of an instruction I have placed. Lordship will see that bunch, my lord, are. My lord, Lordship will see the last second page. This is the another FIR against the present petitioner. While he was, my lord, pursuing, my lord, his posting, my lord, for MBBS. Lordship will see, but I will not read out. Very, my lord, serious allegation. Lordship will see, my lord, it's handwritten. This is the conduct of the petitioner, my lord, while he was pursuing, posting, my lord, for MBBS. In Guwahati. I filed my affidavit, my lord. Not that. Not will issue notice. This one I will not bring into record by affidavit, but just I am placing it, madam. There is nothing, my lord, against the petitioner, but considering his conduct, my lord, if the actions are not taken, there will, my lord, pass a wrong signal, my lord, to the others, as well as the environment of the college. And what we will see the, my lord, FIR page 17, his involvement, whatever is there is mentioned in the FIR, very categorically. Page 17, lordship, annex B.
Now, what is your pair in this petition?
Yes.
Lordship, where is it page 12, Lordship? I am only basically on the expelling part, Lordship. Because trial is yet to commence, Lordship. If he is acquitted from his charges, Lordship, his 6 months of his academic career will be gone, Lordship. And in this regard, I have also submitted one representation, Lordship, before the respondent authority, Lordship. That has also not been considered, Lordship. Annexure F, page 26, Lordship. To the respondent number 3, Lordship.
The principal?
Lordship, that is pending, Lordship. Page 26, annexure F.
Okay, then let there be a direction to the respondent number 3 to dispose of this.
Lordship, that will suffice, Lordship.
Considering the all entire facts, let it take it.
But Mr. Gogoi, while passing the impugn order, whether any opportunity of being heard was afforded to him?
Well, here, well, after the arrest, that's it and all. Well. Whether now, well, anything, well, he can show that he is not involved. He has been caught red-handed, man. The purpose of a so-called will have to be, well, there have to be something that he has to show that I have been prejudiced. But things are apparent, man. As on at least today, Tarsil is there, man. Same PS case, 25 of 25, Nagaon. Nagaon PS.
May I submit one thing, Lordship?
Hmm.
The order was passed on 13, Lordship, and search sheet was
Today,
passed on
I'm saying today.
29, Lordship.
I'm saying today. Today, my lord, whether, my lord, those submission will sustain after the succeed and all has been submitted. That's why I'm submitting. And my lord, so far as the expelling part is concerned, it will be as per the certain rules are there of the college. That there probably they have done it. Disciplinary rules and all, my lord, regarding the student. Otherwise also, my lord, this sort of conduct, apparently. I'm saying, my lord, it's lucky that he has not been, my lord, the admission has not been cancelled, my lord. He's an ambiguous student, my lord. Instead of doing all this, he must wait for 6 months, have some, my lord, manners, and thereafter, my lord, he should pursue his medical.
In the order, nothing reflects, Lordship, under what procedure they have
I've
expelled
also
me,
even seen the,
Lordship.
my lord, earlier FIR, my lord, on conduct. But sort of person is. That's why I'm saying, otherwise, my lord, this will go, wrong message will go to the college, my lord. If they still idle.
Well, let the representation be discussed.
Lordship.
Heard Mr. P. Bardolo, learned counsel for the petitioner, and Mr. P. Gogo, learned standing counsel for the respondent authorities. In this petition under Article 226 of the Constitution of India, the petitioner namely Asik. Mohammed Asik has challenged the order, office order number Nagaon stroke MC stroke 05 stroke 2025 stroke 208 dated 13/1/2025 issued by the respondent number 3. Also, it is to be noted here that by implement order dated so and so, the respondent number 3 had expelled the petitioner from the Nagaon Medical College and Hospital for a period of 6 months. And also they barred him from entering the hostel premises for the aforementioned period. Mr. Cordolo, learned counsel for the petitioner submits that after passing of the aforementioned order, the petitioner hearing has filed on a representation to the respondent number 3 on 13/2/2025. For revoking the aforementioned order, but the same has not yet been disposed of till date. And further, Mr. Cordolo submits that this writ petition may be disposed of by directing the respondent number 3 to dispose of the representation of the petitioner in a time-bound manner. Mr. Gogoi, learned standing counsel for the respondent authorities, also submits that he has no objection in disposing of this writ petition by directing the respondent number 3 to dispose of the representation filed by the present petitioner. However, Mr. Gogoi producing his written instruction before this court
Well,
submits that
4/3/2025, that instruction says that, my lord, he is one and the same person. Though inadvertently it is mentioned as Ali.
the present petitioner and the person mentioned in the FIR dated
Yes, the FIR is the 10/1, 10/1/25.
10/1/2025
5.
is the same person. And that after investigation of the case, charge sheet has already been submitted before the learned trial court. And the matter is pending at the stage of trial. However, taking note of the submission of learned counsel for both the parties, this court is inclined to dispose of this petition by directing the respondent number 3 to dispose of the representation filed by the petitioner before him on 13/2/2025 within a period of 2 weeks from today,
Lordship, 2 weeks, Lordship.
2 weeks. By passing one speaking order. And while passing the speaking order, the respondent number 3 shall afford an opportunity of being heard to the present petitioner.
Lordship.
The petitioner shall obtain a certified copy of this order and place the same before the respondent number 3 within a period of 1 week from today.
Lordship.
Madam, 2 weeks after receiving the certified copy, we will consider the representation
Yes.
after receiving the certified copy.
Yes.
2 weeks. And Lordship indicate that, madam, the authority, the principal will intimate the petitioner for appearing for hearing, madam, oral hearing.
Affording an opportunity.
Oblige, your Lordship.
May I please, your Lordship, my lord, in this case, this is part heart matter, my lord, saying petitioner paid for regulation of her services, office cleaning in the director of secondary education of law. Next, prayer was made for release of area salary, my lord. So order already passed directing to release, but not released till today.
So whether your salary was released?
It is sanctioned, my lord, Annexure 6. My lord, 39,000 already sanctioned in my post, I have annexed it. But
You have
that
not
money is
received
not released, not paid.
Already that 39,000 has already been received by him, and this is my instruction. And it was received on 23/2019, and the sanction was occurred in 4 March 2019.
When he received the amount?
He has received the amount, my lord, 23/2019, my lord. And thereafter, he was not permanently engaged. In my instruction page 2, my lord, where, my lord, from point 4, the rate petition, the petitioner has requested, my lord, page 2, my lord, serial number 4. In the writ petition, the petitioner has requested for regularization of his services along with a claim for releasing his ADR salary with effect from 1/11/2018 to 30/10/2020. It should have 30/10/2022, but wrongly 2018 has written. It may be stated here that he did not serve for the period of free period with effect from 1/11/2018 to 30/10/2022. My lord, serial number 5. Also, the writ petitioner has claimed for releasing the ADR remuneration for the period of with effect from 1/11/2018 to 30/10/2022, but the fact remains that he has not been engaged by this directorate for the period which he has claimed. And my lord, thereafter, however, However, it is to be stated that as per official record available in this directorate, the petitioner had already withdrawn the said amount of remuneration for his services with effect from 33/10/2017 to 31/3/2018, which was sanctioned by order dated 4/3/2019. And my lord, serial number 7. It is also to be stated here that the petitioner was engaged for another 6 months with effect from 1/4/2018 to 31/10/2018 with a monthly remuneration at the rate of rupees 6,500 per month. But due to non-availability of budget provision, the remuneration for the period could not be paid to the petitioner. The Directorate of Madrasa Education was merged with the Directorate of Secondary Education by government notification number so and so dated 1/7/2017. As a result, the head of account was removed from the Directorate of Madrasa Education. As such, due amount could not be paid. In this regard, it is to be stated that this directorate has moved for the creation of new appropriate head of account for the casual employees. On the receipt of approval from the government, this directorate shall take the necessary actions required to release the wages for the rendered period of services whichever from 1/4/2018 to 31/10/2018 to the petition. And my lord, thereafter, I have already trademarked it to receipt. All the receipt. A receipt for payment remuneration to Sri Ratan Majumdar for clearing works in the office of DSC Assam.
So then this first page relates to?
2007.
This first page relates.
No, my lord, I have already trademarked it. And in the
No.
process, it is.
Mr. Sharma, this first page.
Yes, my lord. It is from the secretariat. And due to his last engagement, as the serial number 7, it is stated from 1/4/2018 to 31/10/2018, monthly remuneration of rupees, but due to non-availability of budget provision, the remuneration for the period could not be paid to the petitioner. So,
First
so
to
creation of
first
new head is required here, my lord. And my lord, first is in my lord, with reference to the subject cited above, I am directed to inform that for outsourcing of cleaners for the office premiers and office campus of the Directorate of Secondary Education, director was unable to process tender quotation for engagement of cleaning personnel for outsourcing as the existing head of account is only meant for payment of wages of our regular employees of the directorate. The DSC has therefore requested to create a new head of account as mentioned below for the purpose of outsourcing of cleaners for the office premiers and office campus of the Directorate of Secondary Education. The file is presently with the Finance Department. Finance Department and creation of new head of account is yet to be approved by the Finance Department. So it is lying on Finance Department, my lord, regarding the creation of new head and accounts.
So what amount was sanctioned?
Already he has received
39,000. 39,000.
3/10/2017 to 31/3/2018, as it is mentioned is Annexure 6. I am directed to convey the sanction of Governor of Assam to an amount of rupees 39,000. This is 39,000 for payment of remuneration to the Sri Ratan Majumdar for cleaning works in the office of DSC Assam with effect from 3/10/2017 at the rate of 6,500 per month. The amount is debitable under the header account of 22 and so state plan and non-plan schemes and during the issue with the occurrence of Finance Department. So my God, that 39,000 already he has received, man.
That is earlier period, my lord. Oh, no affidavit filed, my lord. I have no restriction.
I can find it one.
post is lying vacant, my lord, that I'm working, so that I can be absorbed, my lord. One.
39,000.
What?
Only 1 minute.
So, Mr. Sharma,
My lord.
his fare relates to this period from November 1st, 2018 till October 30th, 2022.
Yes.
So the receipt you have produced is relates to a different period.
My lord, here, my lord, paragraph 5 in my instructions, instruction dated 24 to 2025. Also, the petitioner has claimed for releasing his area remuneration for period with effect from 1/11/2018 to 30/10/2022. But the facts remain that he has not been engaged by director for the period which he has claimed.
So, Mr. Hussain, do you have the engagement letter?
Lord, I can produce the original sometime you will be given. And
You
to
will
take it,
produce?
some instructions. I'll produce the original.
Okay. No, if that is your stand, why you have written to the finance department for creation of the different head of account?
No, my lord, this serial number 7, my lord. In page number 2, here, it would page number 3.
No, no, the amount of 39,000 already been sanctioned.
Yes,
So that amount has to be paid to him.
yes, no, that annexer 6, it was letter of 4 March 2019. And amount was paid and he received by 23 2019. So already he has received, as per that sanction, he has received.
No, you come to the pair of the writ petition. Here, he paid for releasing salary from 1st of November 2018 up to 30th of November or 38th of October 2022.
Yes.
So this 39,000 is sanctioned for which period?
For earlier pay.
Earlier period.
Yes, ma'am.
Where is the sanction order?
Annexer 6, my lord. 4319.
He was earlier engaged on a contractual basis, my lord.
There was extension period, my lord. Term to term.
Yeah, my lord. In my instruction, paragraph, and dated the 24 to
No, Mr.
2025.
Soma, you do one thing, you file affidavit.
Yes.
You file affidavit, and in the meantime, Mr. Hussain, you produce the original
My-
engagement letter.
My lord.
Huh? Art Mr. B. Hussain, learned counsel for the petitioner, and Mr. B. Sharma, learned standing counsel for the respondent for this. Mr. Sharma, learned standing counsel for the respondent of authorities is produced written instruction before this court. And referring to point number 5 in the letter dated 24 2025 submits that the petitioner to claim for releasing his area remuneration for the period 1/11/2018 to 30/10/2022, yet for the aforementioned period, he has not been engaged by the directorate for the period he has claimed. That this is Mr. Hussain, learned counsel for the petitioner submits that he will produce the relevant documents before this court on next day. And as for listing the matter on when. When? No, production of this document. Or
It's shorted maybe 6 months.
2 weeks, within 2 weeks. And in the meantime, Mr. Sharma, learned standing counsel for the respondent authorities, may file affidavit in opposition, bringing on record the written instruction he has received from the respondent authorities, if so advised. Place the matter after 2 weeks.
That's not.
The written instruction for this court shall be part of the record.
But for the last occasion, my lord, a direction was given, my lord, to obtain instructions with regard to the applicability of 2003 Act, my lord, with regard to the amalgamated schools, my lord. Now, the petitioner here, my lord, he is basically, my lord, he was an employee of, my lord, ME school, my lord, which school was subsequently, my lord, amalgamated with a high school. And, my lord, there, my lord, he worked as he was an intermediate teacher there in the ME school. Now, my lord, following the retirement of the, my lord, incumbent, my lord, who was a graduate teacher in the high school, he claimed, my lord, upgradation to that post of assistant teacher undergraduate scheme. Now, that was refused. He came before this honorable court. This honorable court directed his examination of his case. Thereafter, they rejected the case, saying that this policy has been withdrawn in 2011, whereas the amalgamation was in 2006. And the amalgamation, if your lordship looks at page 19, he was actually working in a school called Naitor Honapur ME Madrasa, which was amalgamated with Fakhruddin Ali Ahmed High School. If your lordship looks at page 19, annexure 4, clause 6. Now he's an MA in his qualification is MA in Arabic, and with clause 6, lordship will see without prejudice to upgradation scale of pay of teachers working in ME Madrasa at intermediate scale of pay. So in the ME Madrasa, he was receiving the intermediate scale of pay. Now, the school was amalgamated, and one of the conditions was that it is without prejudice to his rights to get upgraded scale in the higher school, high school. Now, Your Honor, the lordship will find that next page, page 20. This is the list of the teachers of the amalgamated school, and your lordship will find his name at serial number 10, Abdul Jalil. He's an MA, his qualification is an MA. And thereafter, your lordship will find at page 21, annexure 5, the incumbent teacher who was holding the graduate post, one Javed Ali, he retired on 30/11/2011.
Annexure?
Annexure 5, page 21, next page.
Yes.
So he prayed that he may be upgraded to the post of the graduate teacher following the retirement of the incumbent. Now, this was in 2012. He filed this application in 2012 after the retirement of the incumbent teacher. Javed Ali, 30/11/2011. Now thereafter, since it was not given, he approached this honorable court and he filed a writ petition 1642/2014. Page 24 is the operative part, where your lordships had directed that the last paragraph to deal with the case of the petitioner with reference to the aforesaid plea and to pass appropriate as expeditiously possible within 3 months. So accordingly, an order was passed rejecting his claim at page 25, next page, Annexure 7. I will read the findings with your lordship. On perusal of records in hand, it transpires that Muhammad Abdul Jalil, herein referred to as the petitioner, was appointed as Arabic teacher in the intermediate scale of pay in the year 1977 in the Ondhabanga ME Madrasa. He was transferred to CEAI ME Madrasa and thereafter to Khilabari ME Madrasa. Thereafter in 2001, he was again transferred to Naitor ME Madrasa, Sonapur. It also reveals that Naitor ME Madrasa was amalgamated with Fakhruddin Ali Ahmed High School, Naitor, in the year 2006, and the post of the petitioner was absorbed in the FA Ahmed High School. Consequent upon amalgamation of the Naitor ME Madrasa with FA Ahmed High School, Naitor, the petitioner had claimed for upgradation from his post from intermediate scale of pay to graduate scale of pay before the inspector of schools, but failed to get any positive results. Hence, he preferred writ petition number so-and-so in the High Court seeking justice. The Honorable High Court, in its order dated so-and-so in WBC number so-and-so, has directed the government respondents to pass orders in accordance with the prevailing rules and guidelines in this regard. The proposal for upgradation of teachers working in intermediate scale of pay having degree qualification to the post of graduate teacher in higher secondary high schools has since been discontinued in the by the government by the OM dated 18/11/2011. After examination of all aspects, it is decided that the claim of the petitioner for upgradation from his post from intermediate scale of graduate to graduate scale of pay cannot be considered. So I have challenged this before your lordship. In the meanwhile, I'll just like to point out, before I make my submissions, I would like to point out one thing. One similarly situated person approached this honorable court. Annexure 9, page 29 is that order. One Afiluddin Ahmed. WPC number 6510/2014. The page 30 is the order. Heard so-and-so. The petitioner is admittedly an MA with BA degree. His school, namely so-and-so, was amalgamated with so-and-so school in 2006 for administrative exigencies and for promoting the interests of the student of the community of the school. When he joined the so-and-so school, he was given the intermediate scale of pay, and following amalgamation of the school with so-and-so, he claimed that he is entitled to the benefit of graduate scale and post against the vacancies that had arisen in the high school, secondary school in the year 2007. So here the vacancy arose in 2011 in my case. However, such benefit has not been given to him by the state respondents, ignoring the provisions of the Assam Secondary Education Specialization Service 2003. The Deputy Secretary of the Government of Assam in the Education Department by letter dated so-and-so wrote to the respondent number 2 informing him that the government has allowed amalgamation amongst others of so-and-so with so-and-so school on conditions inter alia the amalgamation should be without prejudice to the grant of upgraded scale of pay of school teachers working in ME MB schools as the intermediate scale of pay after amalgamation. So same conditions have been given in my amalgamation order also. The petitioner is, however, seeking the grant of graduate scale of pay as per the existing vacancy of the school with effect from 1/12/2012 from the date of earlier vacancy. It is pointed out the Learned Standing Council Education Department that the question of granting graduate scale of pay petitioner does not arise in as much as the posts have to be filled by direct recruitment. He, however, fairly concedes that there is no problem if the petitioner is granted the upgraded scale of pay of ₹1375 to 3375 pre-revised, which is also the pay scale of senior classical teacher. The Learned Counsel for the petitioner is satisfied if such arrangement can be made in favor of the petitioner. Resultantly, the writ petition is disposed of by directing the respondent authorities to fix the pay scale of the petitioner in the upgraded scale of pay of so-and-so, which is the pay scale also to the senior classical teachers with effect from the date of amalgamation of the school. The said exercise shall be carried out in the period of 3 months from the date of receipt of this order. I'm also agreeable to this order if such an order is passed, because this in a similar situated person, a similar order was passed. Now, Your Honor, Lordship will find that that notification of 2011, which of course I could not annex, it was not available. But the education department is annexed at page 36, running page 36 in their affidavit. Proposal for upgradation of teachers in the intermediate post having degree qualification to the post of graduate teacher in the higher secondary high schools. Several proposals have been received by this department for upgradation of teachers working in the immediate post having degree qualification to post of graduate teacher in higher secondary high schools. The post of graduate teachers in higher secondary high schools are filled up by the method of direct recruitment only under the provisions of Rule 8 of the Assam Secondary Education Provincialized Service Rules 2003. There is no provision for upgradation of teachers appointed in the lower cadre having degree qualification to the post of graduate teacher. Rule 7(2)(b)(2). The said rules gives preference to serving graduate teacher having a post degree, PG degree for the post of PG teacher in that school, but there is no preference in case of intermediate teacher having graduate qualification. If there be any preference, it shall be available only when there is a clear vacancy to the post and there cannot be any automatic upgradation or induction into the higher grade cadre to which the incumbent is not appointed. After careful consideration of all other aspects, the government has decided that henceforth no proposal for upgradation of teachers having degree qualification and appointed in intermediate scale of pay be submitted for consideration by the government. Similarly, the proposal for upgradation of graduate teachers to PG teachers should not be submitted to the government. This supersedes all other office memorandum issued in this regard. Now, one of the question would be whether this notification can be given retrospective effect, because my case was covered by the 2006 notification of amalgamation as well as the rules also. Now, before I place the rules, I'd just like to read one paragraph of this affidavit. Paragraph 5.
Yes.
That the deponent, while denying the claim of the petitioner for upgradation to the graduate scale of pay, it is stated that the petitioner's school, namely so-and-so, was amalgamated with Fakhruddin Ali Ahmed's high school by order dated so-and-so. On such amalgamation, the petitioner came under the jurisdiction of the education department, secondary education department. This line is very relevant, Your Honor, Your Lordship. On such amalgamation, the petitioner came under the jurisdiction of the secondary education department. Now, they are trying to take a contradictory stand to this affidavit. On such, the government in the secondary education department by notification dated so-and-so upgraded the existing post of assistant teacher in the intermediate scale of pay per month with graduate incumbent for provincialization of higher secondary school to the post of assistant teacher in the graduate scale of pay per month from the date of issue of the order. The said notification dated 30/12/1993 was applicable in respect of those existing intermediate teachers working in the secondary school at that time. In this regard, the deponent humbly begs to state that the petitioner was working under the elementary education and his service was come under the secondary education department after amalgamation of the school with Fakhruddin Ali Ahmed School in 2006. Therefore, the claim of the petitioner for allowing graduate scale of pay in the strength of the notification dated 30/12/1993 and subsequent notification dated so-and-so cannot be considered. In fact, the notification dated so-and-so is not a notification for granting graduate scale of pay to the assistant teacher of the intermediate scale of pay having graduate qualification, but is a notification clarifying that the fixation of pay in the upgraded scale of pay would be regulated under the provisions of FR 22(1)(a)(2) and fundamental rules and subsidiary rules. Now, Your Lordship, they have not annexed this notification, of course, of 2030/12/1993. But here I may place the rules before Your Lordship, the 2003 rules, because this is very relevant. This is the book here. Page 266.
Education manual.
Education manual, yes, Your Lordship. Page 3. Lordship.
Page number?
Page number 363, it starts. Page 366, I'll be reading. Classes and cadres. 366. Lordship. My Lord has got it. Got it. The service in provincialized schools shall consist of teaching and non-teaching staff. The teaching staff shall consist of the following classes and cadres. Each one of those constituting a distinct and separate cadre on the commencement of these rules. Now, principal, vice principal, we are concerned with graduate teacher, class 2 junior, It includes the cadre of assistant headmaster, assistant superintendent, graduate teacher, Hindi teacher having bachelor degree from any recognized university, classical teacher, Sanskrit, Arabic language teacher. So he's an Arabic language teacher, our petitioner, having bachelor degree from any recognized university. Now, for the graduate scale, he must have a graduate degree with him. And your lordship will then skip the next 2, 3, and come to 6. Junior teacher, junior classical teacher, junior Hindi teacher. Now here, the proviso is very relevant. Proviso, provided that there shall be no fresh recruitment to the cadre of junior teacher, junior classical teacher, junior Hindi teacher, senior classical teacher, and all such existing posts shall stand upgraded as graduate teacher or Hindi teacher, having bachelor degree from any recognized university or classical teacher, Sanskrit, Arabic, SMS language teacher, as the case may be, from the date such posts become vacant either as a result of the retirement of the existing incumbent or otherwise. So all these junior teachers are to be upgraded if they have the qualification of graduation. They are to be upgraded in the vacancy that arises on the retirement of the existing graduate teacher. Now here is a case where Javed Ali retired. Therefore, I claim that I should be given the benefit of this proviso. Now, your lordship will find that this teacher, this particular teacher, the petitioner, he was in the ME school. That was absorbed. There is an admitted position that post was absorbed in the high school. Now, he continued to remain as an intermediate teacher. And he enters into the service of the education secondary department from the elementary department. The moment he enters the education secondary department, the Assam Secondary Education Provincialization Service 2003 is also effective and binding on him. Therefore, once the post of Javed Ali fell vacant, he was entitled to be upgraded in terms of this proviso, because there is no recruitment, understandably. Understandably, with regard to fresh recruitment, there will be fresh advertisement. But here was a case since was amalgamated to this post, and the order of amalgamation, as I pointed out in clause 6, specifically mentioned that it will be without prejudice to his upgradation. Therefore, once the post of Javed Ali fell vacant in 2011, the petitioner was claiming that he should be given the benefit of that particular graduate teacher's post because he was discharging all the responsibilities. In fact, I made a specific statement in my writ petition in paragraph 15, page 7. That for all practical purposes, page 7, my lord, that for all practical purposes, the petitioner has been serving and rendering service as an Arabic teacher in the graduate scale of pay in the amalgamated high school, in as much as the petitioner has been teaching in the higher classes since the retirement of the earlier incumbent. Now, if your lordship goes through the affidavit, they have not denied this contention that I am not discharging my duties as an assistant teacher in the graduate scale and teaching higher classes. This is not a position which has been denied in their affidavit by the respondents. So for all purposes, I'm discharging the duty, I'm teaching in the higher classes, discharging the duties of an assistant teacher within the graduate scale of pay. And therefore, on the retirement of Javed Ali as per the proviso of the 2003 rules, I am entitled to get the benefit of the scheme. Now, what they're trying to say is they're trying to rely upon a notification, saying that this notification has since been withdrawn. When was it withdrawn? It was withdrawn in 2011. My amalgamation was in 2006. Now, thing is that can this notification supersede these rules? It cannot. The rules are very clear that all the teachers who are there, they will be upgraded to the post of graduate teacher as and when the post of graduate teacher get vacancies. There will be no recruitment, further recruitment with regard to the junior teachers. There is no quarrel on that point. Therefore, here, since the petitioner was absorbed His services was absorbed under the secondary rules, under the secondary streams or secondary rules, in the high school. So once it was absorbed, this 2003 rules becomes applicable to him. And as and when the vacancy arises, it arose in 2011 in this case, and therefore he is entitled to the scheme. More so when he is discharging the duties of the graduate teacher and teaching in higher classes, which they have not denied. Therefore, in my humble submission, the petitioner is entitled to the reliefs as prayed for. And I'll be relying upon one judgment also of the Honorable Apex Court. It's a very small judgment. Paragraph 3. It is not in dispute that the appellant looks after the duties of Secretary Scouts from the date of the order, and his salary was to be drawn against the post of Secretary Scouts under so-and-so. Still, he was not paid the salary for the work done by him as Secretary Scouts. It is of course true that the appellant was not regularly promoted to the said post. It is also true, as stated in the counter affidavit of so-and-so, that the appellant was regularly posted in the pay scale of so-and-so, and he was asked to look after the duties of secretary as per the aforesaid order. It is true that this arrangement had not been done. He would have been transferred to the interior stands with the island, with the post of PST was available, but the appellant was keen to stay in Port Blair as ever in the said counter. However, in our view, the averments in the counter will not change the real position. Fact remains that the appellant worked on a higher post, though temporarily, or in an officiating capacity pursuant to the aforesaid order, and his salary was to be drawn during the time against the post of salary scouts. It is not in dispute that the salary attached to the post of secretary was in the pay scale of so-and-so. Consequently, the principle quantum merit, the respondent authorities should have paid the appellant as per the emoluments available in the aforesaid higher scale of pay scale during the time he actually worked in the said post of secretary, though in an officiating capacity and not as a regular promotee. This limited relief is required to be given to the appellant only on this ground. So here is a case, even he might not have been promoted, but he was discharging the duties of in the higher sections, and that is not being disputed. The affidavit doesn't have a whisper saying that no, he was not teaching in the higher classes. Number one. Number two, the provisos are very clear. Once the vacancy arises, these junior teachers who are already in the stream or in the school or in the process in the establishment, they will be upgraded to the graduate teachers post in the vacancies that arise. There will be no further recruitment of junior teachers. Understandably so. What they're trying to say is that since there is no this posts are to be filled up by direct recruitment, but they're ignoring the fact that the proviso is there, which specifically mentions, which specifically says, as per the rules, that these teachers are entitled to be upgraded to the graduate scale. Of course, he must have a graduation. He must be a graduate. Here is the petitioner is an MA in Arabic. So therefore, there's no question of disputing with regard to qualification. That is also that they have not disputed. Therefore, in my humble submission, the petitioner is entitled to the scale, either the upgradation of the post or even the scale as it was given in the other case, similarly situated persons. Either of them would be happy because he has already retired. It's 2015. He was retired almost 5 years now. This is a case filed in 2015. And today he is in 2025, Your Lordship.
Who is responsible for the same? Who is responsible for the same?
This case came up for hearing a number of occasions and never it ultimately could be finalized.
Why?
I don't know why. I have not say much.
No, you are the counsel for the petitioner. You must.
It was argued. It was argued. Then they took time. This and that. It is kept on happening. But it's not as if the case has not been coming up. It has been coming up from time to time. That's also a fact. They have filed affidavit. Then they sought clarification. This and that.
There is one provision in the ROP 2017 perhaps, where it is recommended to give this graduate scale to those teachers who have to those employees who have obtained graduation during the course of their employment.
Here is a case, he got it much before, he was a graduate much before, he was an MA in 1988.
That's all right.
So,
Can you find it out? Because that may also help you.
yes, yes, of course, I did not go into that. I have to try to find out. Because I think,
ROP 2017.
ROP 2017, I'll just try to find out.
Mr. Dutta, I can furnish the copy, hard copy to you. Can you find it out?
Yes, sure, sure. Lordship will take it after some time, or Lordship will hear them.
Yeah.
Try to, in the middle, try to find out.
Yes.
My lord, in this matter on loss of a job, my was directed to
Obtain instruction.
instruction regarding whether provision to rule 3 of Assam secondary provincialization of service rule 2023 applies to the teachers of any school which have been amalgamated with the high or higher secondary schools. So my lord, as per our view, it is stated that the proposal for upgradation of teachers working in intermediate scale of pay having a degree qualification to the post of graduate teachers in higher secondary or high school has been discontinued by the government office memorandum dated so and so and dated 18/11/2011. Further, it is also stated here that the Assam Secondary Education Provincialized Service Rule 2003 as amended 2012 has been replaced by the Assam Secondary Education Provincialized School Service Rule 2018. As per clause 35 of Assam Secondary Education Provincialized School Service Rule 2018 stated that the Assam Secondary Education Provincialized Service Rule 2003 order or notifications corresponding to these rules and enforced immediately before the commencement of these rules are hereby repealed, provided that all orders made or action are taken under the rules to repeal or under any general order ancillary thereto shall be deemed to have been validly made or taken under the corresponding provision of these rules. And you want that this is.
So as per your instruction, this rule is not applicable.
Yes, yes, madam. It is already repealed.
No, but
No,
here is
the school was amalgamated in the year 2006.
Six.
But my lord, the existing rule is 2018, my lord. 2003 rule has already been repealed by the 2018 rule, my lord. So now all the procedure followed under the 2018 rule, my lord.
My case, my lord, my claim did not arise after 2018 rules. My claim arose much prior when the 2003 rules were in force. So therefore, they cannot retrospectively apply 2003 rules by saying that it was repealed in 2018. My case, I had filed, even this case was filed before 2015, in 2015, much before this rules was repealed. They're just trying to negate this payment
This
by
instruction
taking.
has come, instruction has come after the honorable court has directed us whether this provision of the rule 3 of the Assam Service Rule 2003 is applicable or not.
Now, this affidavit was filed in 2023. Where they did not take this stand. This affidavit is filed in 2023, much after 2018. Now, they don't take this stand there. Now, by way of written communication, of course, this honorable court directed them to obtain the instruction. Now they say that this act is repealed. Act is repealed in 2018. 2018 rules, my case claim was much prior to when the 2003 rules was in force. Just because the matter has been kept pending, that cannot be the ground that they will say that no, this cannot be granted because he'll be governed by the RDA rules. And the order of amalgamation is very clear that without prejudice to his the right to upgradation. So therefore, that was also there, terms and conditions of the amalgamation was one of that, he will be entitled, those who are graduate teachers, they'll be entitled to the graduate teacher scale on such upgradation. And the conditions of the rules was that the vacancy is to be there. He cannot automatically get it, but when the vacancies arose in 2011, he claimed that now since I'm teaching in the higher post, kindly give me that skill. And that is not in dispute. They've never said that, no, you are not serving, you are not teaching in the higher classes, you are teaching in the junior classes. That is also not the case.
But my lord, now new head has come and all the procedure, all the appointment, all upgradation are go through the my lord, that June, my lord, 2018 June, my lord.
The benefits which flow under the existing service rules, there cannot be changed to the detriment of the person concerned. That's a settled law.
I lord, earlier in this matter, Kaushik was appeared, my lord, so he is to the out of station, my lord. So next week,
This is why the matter has been pending for so long. Every time they come with some kind of excuse, some kind of new instruction, and then get the matter delayed.
No, we have already filed our affidavit and move on as per queries of the honorable court. We have.
Sir, you argue the matter, argue your case.
My lord.
You argue your case.
My lord, I am relying on our affidavit, my lord, here. No, my lord. Here, page 33, my lord. From the first line, my lord, the case of the petitioner is there. While he was working in Swansea Madrasa, the said school was amalgamated with the Fakulty Ali Ahmed High School, right? Order that Swansea with the condition that without prejudice to upgradation of a scale of pay, working in AMI Madrasa in intermediate scale of pay. However, the claim of upgradation from his post from intermediate scale of pay to graduate scale of pay was rejected, right? Order that so on the basis of office memorandum dated 18/11/2011. And annexure is dear my lord. And the claim of the petitioner for upgradation was also based on the notification dated 7/2095. And therefore, my lord. And my lord, annexure is page 36. My lord, I would like to read the office memorandum. The several proposals have been received by the department for upgradation of teachers working in intermediate post and having degree qualification to the post of graduate teachers in higher secondary high school. The post of graduate teachers in higher secondary high school are filled up by the method of direct recruitment only under provisions of Rule 8 of Assam Secondary Education Provisionalized Service Rule 2003. And there is no such provision for upgradation of the teachers appointed in lower cadre having degree qualification to the post of graduate teachers. Rule 7(2)B, subclause 2 of the said rules give a preference to serving graduate teachers having PG degree for the post of PG teachers in the school. But there is no such preference in the case of intermediate teachers having a graduate qualification. If there be any preference, it shall be available only when there is a clear vacancy to the post and there can not be any automatic upgradation or induction into the higher cadre to which an incumbent is not appointed.
But his cases of the year 2006, his office memorandum is of dated 2011. Then prior to that, there was another office memorandum of the year 1993, 38/12/1993. So at the relevant point of time, that notification was in force. Are you aware of this notification? 30/12/1993. Not aware of. And perhaps that notification is not available with you also.
Yes.
So with this instruction only, you came to argue before this court.
No, regarding my, regarding the.
So
query of the
in the affidavit itself, you have mentioned, come to paragraph, page number 37. The notification dated 30/12/1993. Have you seen? No. For the first time you have heard it.
So regarding that, my lord, I have to collect that notification. One,
No,
sometime maybe
no,
can.
no further adjournment. This is a 2015 matter. Yes. No further adjournment.
Next week, my,
Pardon?
next week, my.
No, no. No adjournment. You argued the case today. We'll take it up in the second half then.
My lord, my lord. My lord, I found one place where, my lord, this
Yes.
is mentioned, my lord, page 299. Of course, this is with regard to finance department, my lord. My lord, there is some, my lord, scale, my lord, we granted, my lord.
Yeah, we'll resume after 5 minutes.
Lordship will take up.
Okay. As right for by Mr. AI Uten, learned counsel for the future. Applicant, Raisa Liza matter. But
Monday or Tuesday? Only.
it is a children celebrity.
Tuesday দিলে Monday দিলে I am available.
Matter, my lord, regarding finalization of pension and the payment of a year's salary. They have to file affidavit, but in the last occasion, you will find order dated 31/2025. It was directed to release the provisional pension, which was granted, but not yet been released. On the ground that there is some defect on the pension papers, but I have to sign, but that is regarding finalization of pension, final pension, and not regarding release of provisional pension. So as per a lordship will find, there is a order dated. In order dated is reflected that the director has already sanctioned the pension by letter dated 11/9/24.
Page number?
Lordship, it is on the order sheet, order
Pardon?
31/25. It is reflected manner. Lordship got it.
Yes.
Correct, 2 minor. Mr. BTC submits that provisional pension of rupees 39,000 in favor of the applicant petitioner has been made with effect from 1 to 24 to 31 and 25. In this regard, he has
So
submitted
whether
an
you have attended the office of the principal of
Lordship,
Disney
Lordship, I was called in the office of the director, madam. Director, because paper was sent to the director office. And
Lordship, one thing, repeatedly the petitioner is not cooperating for finalization of the pension proposal. Lordship, earlier it was sent, the director of pension returned it back because there was wrong fixation of the pay scale. After correcting it, thereafter she is required to sign some of the papers. That she is not cooperating. And as in
That is, my lord,
that friend,
that I will sign, but regarding my provisional pension, there is no dispute, my lord. Provisional pension,
Lordship, provisional pension, after correcting the pay scale fixation, then only on that basis it has to be calculated. For that also, she is also not cooperating to sign the paper. Then Lordship, the matter
No,
gets.
Mr. Sodari, wait for a while. Mr. Nath, by order dated 20/2/2025, this court has directed you to remain present in the office of the principal.
Lordship.
Whether you have attended the office.
Lordship, I went to the wish of the director, my lord. Principal.
What was the direction in the order?
Lordship, director asked me to attend his office, my lord. That's why, not accordingly, I
No.
then
You come to the order. It's third paragraph of the order.
then I have to take instruction, my lord, because I have no up to
What
date instruction
instruction?
regarding the attendance of the principal, office of the principal petitioner.
So what was the direction of this court?
Direction was to attend and to cooperate and to sign the papers.
Attend
But in the meantime,
office?
I was asked by the director to attend his office. My instruction is that, my lord, she attended to the office of the director, Kokrajhar, and there was some defect in the papers. That's why that could not be materialized. And in the meantime, director has passed another order sanctioning, my lord. That order is not along with me, my lord. It is. So, my lord, matter may be taken on the next week, my lord. I will appraise your lordship that what is the up to date.
So this court has directed you to attend the office of the principal of Bonham SS School. And you have attended the office of the director.
Yes, my lord. Because the director asked me to papers are placed before his office, my lord, director office.
You first carry out the order of this court.
Lordship, I communicated with the principal. Principal in turn said that I have sent the paper to the director office. So accordingly, there is some misunderstanding, and also director asked me to appear in the next week so that the paper could be.
Okay. But Mr. S. Not learned counsel for the petitioner and Mr. Bixodori, learned standing counsel for the petitioner and Mr. U.
NK Boromai.
For
Number 7 and 8.
Testimony number 7 and 8. Mr. Nath learned counsel for the petitioner summons that in respect of the direction issued by this court, while order dated 28th of February 2025, directing the petitioner to attend the office of the principal Bizni Bandhap SS School with regard to the issue of fixation of the pay of the petitioner's husband. He will obtain necessary instruction from the petition and tries for listing the matter in the next week. Here is allowed listing the matter.
Plus, that is wrong. Not husband, my lord. Petitioner is the petitioner, not husband. That was wrongly mentioned, my lord. Petitioner should attend. Petitioner is the, my lord, retired employee.
Respect of your husband, right?
Lordship?
In respect of your husband.
No, my lord. Petitioner herself was the subject, my lord. That was wrongly mentioned.
You cannot correct it. You have to file an IA to this effect. In respect of petitioner.
Obliged. May I please, your Lordship?
Yes.
Lordship, my lord will kindly turn to page 76, my lord. There were altogether, my lord, there was a dispute, my lord, earlier, my lord. Two schools were there.
On the earlier occasion, we have published our report also.
Let me make my submission.
And some photographs were also there.
Lordship,
Some photographs along with the report were placed before this. That is the-
let me place my case, please.
Before you start.
Why? This is my case. Let me place my case. My lord will kindly have a look at page 76, my lord. There was a dispute, my lord. There were altogether two schools, my lord. And there is a speaking order, my lord, page 76. My school was found to be, my lord, the genuine school, my lord. The concerned director, wide order dated 19/8/2016, my lord.
Yes.
My lord. Page 76, my lord, of the petition, my lord.
Yes.
My lord. If your lordship kindly, my lord, turn to page 76, the statement submitted submitted on 19/12/2015 by the petitioner Muhammad Azizul Haq, BEO Batodraba and Mohan Baharul Islam, respondent number 7. He was the other party. Habibur Rahman and 8 Ariful Siddiq with other relevant particulars stroke documents of the school in the hearing which was held in the office chamber of Additional Deputy Commissioner Nogam on so and so at so and so, along with petitioner respondent number 7 issued by his office letter so and so. Findings: Dakhin Kodamani Puthar VLP school established in the year 3996 by the local people at Dakhin Kodamani Puthar village so and so. The school have entered a plot of land measuring so and so under so and so in the district of so and so. As per records of 2009-10 Dias Code, it has seen that there were 3 number of teachers who were working in the school as follows: Habibur Rahman, Taizuddin and Azizul Haq, assistant teacher. Habibur Rahman was appointed by the SMC in 2009 with resolution number 1, and he had left the school for Chennai in the year 2010 to join some other establishment. Because of his unauthorized absence in the school, the SMC of the school in question terminated the said respondent, that is Habibur Rahman, who on his return from Chennai illegally opened another school using the name of petitioner school in the same locality with respondent number 8. He then DEO Nogam make an inquiry on 28/2014 in this regard and found that the petitioner school is running in order. Recorded the names of the petitioner as teacher of the said school. After 28/2014, the respondent number 7 and 8, that is Habibur Rahman and Muhammad Ariful Siddiq, has established a new school with the same name and style with the following documents. Number 1, Dakhin Kodamani Puthar LP School has been running, headed by Muhammad Azizul Haq, with the following teachers. Number 1, Muhammad Azizul Haq, head teacher. Taizuddin Ahmed, assistant teacher. The school has been running on Dag number so and so and Pata number so and so, 1 bigha area of land which was donated by so and so. Dated 10/3/2005. Number 1, Dias Code number so and so, year 2009-10. Admission register has shown since beginning in original. Proceeding book has shown since beginning in original. Teachers attendance register has shown since beginning in original. Inspection book has shown in original, headed by Azizul Haq, head teacher of Dakhin Kodamani Puthar LP School in original place. Number 2, Muhammad Habibur Rahman headed the Dakhin Kodamani Puthar LP School, which has been running with approximately 100 meters distance from the original first PLP school with the following teachers. Habibur Rahman, head teacher, Ariful Siddiq, assistant teacher. The school has shown the land records same as mentioned at point number 2 above, as Pata number so and so, Dag number so and so, under Kodamani Kisamat Moza, Batodraba, where actually the school has been running. Dias Code number so and so, admission register has shown since the beginning of the school. Proceeding book, police station report submitted and some photocopy enclosed. Inspection book, PS report submitted, few photocopy of inspection reports also submitted. Teachers attendance has shown since the beginning of the school but not running in its original place. Number 3, as per result instruction of the Additional Deputy Commissioner Education Nogam, the chairperson DLRC Nogam and the DEO Nogam has asked Muhammad Habibur Rahman to submit original land records, land documents of the school in connection with WBC so and so, by his letter number so and so, dated so and so, and also issued reminder by number so and so, dated so and so, but Muhammad Habibur Rahman could not submit the original land records of the school. On the other hand, the petitioner Muhammad Azizul Haq has submitted the original land records of the Dakhin Kodamani Puthar LP School, where the school has been running in the plot of land by Dag number so and so, Pata number so and so under Kodamoni Kisamat Moza, Botodrova. Decision from the above facts and figures with relevant particulars, original land records, land documents, DIAS code, statement, proceeding book, and inspection report. It reveals that Dokhin Kodamoni Pothar VLP school, which is headed by Muhammad Azizul Haq, is the original school, contrary to the school headed by Habibur Rahman, which has been established later on. This is in compliance with the Honorable High Court's order dated so and so, passed in WBC number so and so. As such, my lord, my school was found to be the genuine school, my lord. Thereafter, my lord, the DIAS data, my lord, which was taken away by the, my lord, concerned authorities. There was a communication, my lord, and the inspection also, my lord. My lord will kindly have a look at the inspection report conducted by the SI of schools, my lord, page 84, my lord. This was carried out by the, my lord, SI of schools, Botodrova Circle, Nagaon, Assam. My name appeared along with the assistant teacher of the school, my lord, others, along with the number of students and, my lord, and there is a communication, my lord, made by the, my lord, concerned district officer to issue a fresh DIAS code or to return the, my lord, earlier DIAS code. Page 96, my lord, is the communication dated 31/5/2017 made by the DO, my lord. Page 96. My lord. Lord, she will kindly come to page 96, my lord, now. For a moment, my lord. My lord. Subject is DIAS code for Dokhin Kodamoni Pothar LP School. Reference is High Court's order and DO letter number so and so. Madam, with reference to the subject cited above, I have the honor to state that Honorable High Court, Guwahati has issued an order against Dokhin Kodamoni Pothar LP School of Botodrova block. That, Madam, two parties as follows has claimed against the Dokhin Kodamoni Pothar LP School headed by Muhammad Azizul Haq, number 1, number 2 headed by Habibur Rahman. The Deputy Commissioner Nagaon has organized a hearing meeting of both parties, checked the original documents, etc., and issued a speaking order that the school headed by Azizul Haq is the original school with DIAS code number so and so of 2009-10. The other school headed by Habibur Rahman is not original school. So, DIAS code may be either renewed or issue a fresh DIAS code to the school headed by Muhammad Azizul Haq. This is forwarded for your kind information and necessary action, my lord. Now, my lord, the impugned order, my lord, you will kindly have a look on the next page. This was passed by the, my lord, concerned director, my lord. I have been, my lord, deprived, my lord. The operative portion starts at page 98, my lord. If I may go to the page 98, my lord. Second paragraph. As per office records, has my lordship found, my lord? My lord. As per office records, it is seen that DEO Nagaon had submitted the proposal for provincialization of services of this teachers along with recommendation of DSC Nagaon in respect of Dokhin Kodamoni Pothar LP School. The said proposal as received from the DEO Nagaon was placed before the SLSC and joint committee constituted by the government under the chairmanship of Sri R.C. Jain, retired IAS so and so, for examining the proposal for provincialization of services as per Act 2017. The committee, by its minute dated so and so, decided to instruct MD SSA to verify the following criteria in respect of the proposal submitted for provincialization of services. Number A, whether this name of the school appears in the DIAS data of 2009 or before. Number B, whether the name of the incumbents appears in the DIAS data of 2011 and afterwards. Number C, enrollment position of the school during 2016, 17 and 17, 18. Accordingly, SSA Assam had submitted the DIAS data maintained by NUPA in respect of the school of the petitioner, Dokhin Kodamoni Pothar LP School. As per the report furnished by the SSA Assam, it is shown as no enrollment on UDIAS in the database maintained by NUPA for the year 2016-17. In respect of the school petitioner, Dokhin Kodamoni Pothar LP School, DIAS code number so and so. The DIAS code being the same as furnished by the petitioner in respect of his school, Dokhin Kodamoni Pothar LP School. The name of the teacher could not be recommended for provincialization of service of the teachers against Dokhin Kodamoni Pothar LP School by the SLSC as well as the joint committee decision wide minute dated so and so due to non-fulfillment of the enrollment criteria as per the clause 3.1 Roman 12 of the Act 2017. Whether it is laid down that the DIAS code of the school was so and so during 2009-10 and as per DIAS data, there was no enrollment in the year 2016-17 in the school Dokhin Kodamoni Pothar LP School.
Being aggrieved, the petitioner Azizul Haq filed the present writ petition in the Honorable Guwahati High Court by WBC number so and so with the claim that DSC Nagaon had furnished the particulars of the other fake school in the same name for provincialization of service as per Act 2017. The Honorable High Court passed order dated so and so in WBC so and so that the appeal dated 10/2/2021 preferred by the petitioner under section 14 of the Act 2017 be given its consideration and brought to its logical end. Accordingly, the state level scrutiny committee, come Director of Elementary Education, Assam, is directed to give consideration to the appeal dated 10/2/2021 preferred by the petition under section 14 of the Act 2017 and pass a reasoned order thereof. The SLSC examined the following points. Number 1, as per clause 3(1) Roman 12 of Provincialization Act 2017, the enrollment shall be verified with the DIAS data as per DIAS Code 2009-10 or before maintained by National University of Educational Planning and Administration, New Delhi. Number 2, on the other hand, government in the Elementary Education Department has constituted a joint committee under the chairmanship of Sri R.C. Jain, retired so and so, for examining the proposal for provincialization of services as per Act 2017. The committee, by its minute dated so and so, decided to instruct MD SSF to verify the following criteria in respect of the proposal submitted for provincialization of services. Number A, whether the name of the school appears in the DIAS data of 2009 or before, whether the name of incumbent appears in the DIAS data of 2011 and afterwards. Number C, enrollment position of the school during 2016 and 17-18. And the next page, in view of the above, the committee examining the stated facts is of the view that the school Dakhin Kodamani Pothar LP School with DIAS code so and so doesn't fulfill the criteria as laid down in the clause 3(1) Roman 12 of the Act 2017. Since the enrollment position of the school during 2016-17 is shown as no enrollment on used DIAS in the database maintained by NUPA for the year 2016-17. Hence, the committee decided to stand by the decision by the earlier SLSC and joint committee constituted by government, and therefore the committee and also decided that claim of the petitioner for provincialization of services of the teachers against Dakhin Kodamani Pothar LP School as per Provincialization of Services Act 2017 cannot be considered. This is the finding of the Director of Elementary Education. Now, if your lordship compare, kindly compare along with this impugn order, along with the communication made by the concerned district officer, page 96, Annexure 23. Because of the dispute having two same schools, my DIAS code was captured by the concerned authority, mission director, SSA. And in this particular communication, there was a request made by the district elementary education officer come district mission coordinator to issue a fresh DIAS code after 2009 or to issue a to renew the earlier DIAS code. In fact, after making this communication, no such DIAS code was ever issued or the earlier DIAS code was never renewed. Therefore, that stand taken by the concerned director at this stage, by passing this impugn order is not sustainable in the eye of law, saying that our school did not have any enrollment in the year 2016 and 17. And regarding this instruction which was produced by my learned friend on other occasions, earlier occasion, he had produced some photographs along with the reports, saying that on the day of inspection conducted by the other deputy director of the school, nobody was found in the school, and no student was also found in the school. My humble submission before your lordship is that, on that particular day, one of my relative, he had died, and the headmaster himself and the assistant teacher of the school, both are brothers. Since they had to leave the school on compulsion, as such, the director did not meet any of them, nor the students. There was no other students in the school, since the school was headed and run by these two teachers only, the headmaster himself and his brother. Therefore, on the day of inspection, the concerned deputy director, he did not found any students in the school, nor he found any teacher in the school. This is my humble submission. And regarding this particular stand taken by this concerned director, my lord has already issued two judgments and order in my favor, very recently, she will kindly have a look. I'll produce, this was passed on 30/9/2024. Another one is there. Another one is on the last day of this February month. I may be allowed to produce both these orders. These are very recent orders, One is my lord Deepa Devi, if your lordship my lord remember my lord, just 2 weeks back. my lord. Lordship has pronounced the judgment in my favor. This case my lord squarely covers this particular petition, my lord. Present case as well as the other case also, my lord. WPC 3854 of 2022, that is my lord Zinnatul Nahar. This was, the order was passed on my lord 39/2024. That was passed by my lord, my lord. In this particular order, my lord, regarding this Deepa Devi, my lord, this is the latest one. This was passed on, my lord, 28th of my lord, February 2025. This judgment, my lord. Both these cases, my lord, squarely covers my case. My lord. Lordship will kindly go through, my lord, of the judgments and will pass necessary order.
Yes, Mr. Corman.
Lordship, here in terms of the Honorable Court order in the present date petition, dated 7/11/2023. The physical inspection was conducted. But I have said before not, along with the photograph, there are copy of the photograph. On inspection, there was no teacher, no student. There was, and there is the,
No, whether before inspection you have sent any notice to the principal or to the school headmaster?
No.
to that extent, I have no instruction as of now, but I will after instruction.
No.
What?
How you have to carry out the inspection? First,
Yes.
you have to notify it.
Not so, yes, but that's to go.
My lord, I have the
Yes, has to
instruction.
go, and then Lordship. Then let me bring this report on record by way of an affidavit, let my learned friend.
No, my lord, they could have filed their affidavit, my lord, much earlier occasion, my lord. I'll leave it to your lordship, my lord, by submitting this, my lord, two judgments, my lord. These, my lord, two cases squarely covers my case, my lord. No, my lord. My lord, this man is suffering, my lord.
Respond.
My lord will kindly consider, my lord, this man is suffering from right from the 2013. There were number of, my lord, round of writ petitions, my lord. My lord, at last, my lord, his school was, my lord, declared to be the genuine school, my lord. Even, my lord, the proposal was sent by the district scrutiny committee for further consideration. My lord, saying that, finally, my lord, the commissioner has said that that there was no enrollment in my school in the year 2016-17. Whereas, my lord, the original fact is that it is apparently clear from the communication made by the, my lord, district officer that the DIAS code was never renewed and it was not issued also, my lord, afresh, my lord. This cannot be a ground, my lord. Lordship will kindly consider my case, my lord, on the basis of these two judgments, my lord. Lordship himself has passed, my lord. Lord, similar grounds were taken, my lord, in the earlier cases also, my lord. Those were not found to be sustainable in the Isle of Law, my lord. Therefore, no further instruction may not be required, my lord. And the instruction that I have, my lord, that no notice was ever issued to me, my lord.
In the year 2009 and 10, DIAS code was issued to the school.
Yes, my lord. That is also admitted by the, my lord, the concerned communication made by the, my lord, district officer, my lord. Page 96, my lord. Lordship will kindly have a look. The number, DIAS code and the year is also there reflected. Page 96, annexure 23, my lord. In the first paragraph, my lord, the second paragraph, the Deputy Commissioner Nagaon has organized a hearing meeting of both parties, checked the original documents, etc., and issued a speaking order that the school headed by Muhammad Azizul Haq is the petitioner, my lord. Is the original one with the DIAS code number 0102715. This is the DIAS code of 2009 and 10. 2009-10 DIAS code is there, my lord. Thereafter, my lord, they did not issue any fresh, my lord, DIAS code either, nor, my lord, they
No, that's
renewed
all
the.
right, but whether you have submitted the proposal for entering the data in the DIAS code.
My lord, this is a, my lord, communication made by on behalf of me by the district officer before the director, my lord. Lordship will kindly have a look in the heading, my lord. to the mission director.
In the case of issuance of dice code, Lordship, if there is a gap period, it cannot be renewed because Lordship, it's in the portal and maintained by the central government. There is a particular window period when there any correction or new entry that has to be incorporated, and the application has to be from the school. Lordship, because if some school is
That's all right. That is the procedure.
that is the procedure, because the earlier data, there may be some plus or minus, or the teachers may have retired, or some new have maybe inducted into the service. So the proposal has to be there from the school.
My lord, on the
Only
basis of the
from the
proposal, I'm
SSC
submitting.
cannot, correct it.
My lord, on the basis of the proposal made by the my lord school, my lord, the headmaster of the school, this communication has been issued, my lord.
No,
This,
that's all right, but whether he had made any communication regarding entering the dice code for the other year
my lord,
after 2009 and
after 2009 and 10, my lord, it was never, my lord, issued to us in fresh, nor it was renewed, my lord. Therefore, my lord, in the year, my lord,
Every year it
there
has
are
to be
2017, my
on
lord,
the basis of
my lord, in the year 2017, my lord, therefore,
No, Mr. Hamad,
my lord,
for each and every year you have to send the particular
yes, my lord,
for entering the data in the dice code. Whether you have sent the documents.
my lord, we did not send for each and every year, but this communication speaks that after, from 2009 until 2017, my lord, this communication has been made by the concerned officer, my lord, district officer, saying that it has to be, my lord, either released, my lord, or renewed, my lord. Otherwise, my lord, this cannot be continued. We cannot continue it, my lord. It is the authority, Sarva Shiksha authority. They will have to, my lord, reopen it or my lord, issue a fresh, my lord. Otherwise, it is not possible. And my lord, regarding this part, my lord, continuation of dice, my lord, this Deepa Devi's judgment, my lord, it has been clarified by your lordship.
No, that will not cover your case. You see this.
My lord.
In Deepa Devi case, there was a environment that the data were forwarded in each and every year.
In each and every year.
But in this case, whether the headmaster has forwarded the data to the SSA for honor transmission of the same to the NOPA for entering it in the dice.
My lord, he did not make any communication every year, my lord. He did not make any communication.
Then what
to
is the
continue.
requirement?
My lord,
What is the requirement?
my lord, requirement was that, my lord, on the basis of, my lord, this communication, my lord, made by the district officer, my lord.
No.
Had it been opened by the, my lord, or released by the, my lord, Sarva Shiksha authority, my lord, then only, my lord, headmaster could have, my lord, prayed before the concerned authority to continue it, my lord. Otherwise, he cannot, my lord. Since there is already a communication, and on the basis of communication, my lord, this communication, the concerned, my lord, mission director should have responded, my lord. He never responded, my lord. This was not made by the, my lord, headmaster of the school. This was made by the, my lord, mission.
No. Mr. Koduri has pointed out.
Yes, my lord.
That this communication was made in the year 2007.
Right.
So the data relates to the year 2010, 11,
Yes.
11, 12
Yes.
onward.
Onward.
And Mr. Soturi has pointed out that there is a window period. Only during that window period, the data can be entered and modified and rectified. Otherwise not. So can the SSA on the basis of this communication can modify the data or reissue the data?
My lord, if this would have been the system, my lord, in the impugn order, my lord, the commissioner would have never said that from the NUPA records, my lord, pertaining to the year 2016 and 17, then there was no enrollment in my school, my lord. Since because after 2009, my lord, this data was never issued to our school in fresh or it was renewed, my lord. Therefore, the question of, my lord, making it, my lord, maintaining it in NUPA, my lord, doesn't
there
arise
is
at all,
a-
my lord. Therefore, my lord, this stand taken by this, my lord, commissioner itself, my lord.
There is a provision in the act itself
Yes, my lord,
that there must be continuous service for a period of, yes, what is the section, Mr. Sharma? For how many years the DIAS data has to be reflected?
Lordship.
At least for 3 years, my
The
lord.
institution has to be, the data has to be reflected.
For
prior to
continuously for?
2009-10.
Continuously for?
Continuously for 3 years, Lordship, 2011 and 12 onwards in respect of the teacher. It has to be reflected.
3 years or you check the provision properly.
My lord, lord,
11 and 12 onward. An institution name has to be there prior to 2009 and 10.
not prior to, my lord, it is right from the 2009-10, it has been given, my lord. Page 111, my lord.
111.
Roman 12, my lord, section 3.
2017. Enrollment shall be verified with the data as
Page number?
111, my lord.
Yes.
The enrollment shall be verified with the data as per DIAS code 2009-10 or before as available in the records of the National University of Educational Planning and Administration, New Delhi. There shall be physical verification of students and checking of records of attendance of students as last 3 years, of last 3 years.
verification of last 3 years.
So, my lord, without verification, my lord, how come, my lord, the findings has been made, my lord, by the concerned, my lord, commissioner? When the, my lord, my DIAS code was never extended or not issued afresh, my lord, how come the, my lord, the director has said that in the impugn order, my lord, saying that in the NUPA, the data maintained by NUPA, my lord, there was no enrollment in my school in the year 2016-17. Since it is an admitted question of fact, my lord, admitted, my lord, in my case, that my DIAS code was never released, nor it was issued afresh, my lord. Therefore, my lord, NUPA cannot, my lord, maintain any data, my lord, till 2016-17. This is a wrong stand, my lord, taken by the concerned, my lord, commissioner, my lord. And this section 3, subsection 1 and Roman 12 has been referred by the concerned commissioner. By referring this section, my lord, this stand cannot be taken, my lord. The DIAS data was issued in the year 2009 and 10. Yes, my lord. That is correct and true. But thereafter, my lord, it was never, my lord, continued by the authorities because of the dispute between the two schools, my lord. And finally, my school was headed by the petitioner, my lord, was found to be genuine school, my lord, for several years, my lord. This Deepa Devi's judgment will, my lord, clarify, my lord,
No, no,
everything.
no, no.
And on not only this one, my lord, the earlier case,
There is
a little bit difference, my lord. The difference is there in Deepa Devi and this one, my lord. Deepa Devi's name, my lord, my name continued till 2011, and thereafter, for some period, my name discontinued. Again continued.
how this Deepa Devi's judgment will cover your case?
Will not cover totally, my lord, but partially it covers, my lord. In that particular case,
Therefore, this honorable court by the order dated 7/11/2023 directed the department to conduct a physical inspection and furnish the report. So that physical inspection only to the point that whether before conducting physical inspection, whether the notice was published or not, that we have to obtain instruction. But in terms of this honorable court's order dated 7/11/2023, lordship, physical inspection was conducted. On physical inspection, lordship, as I have already placed before the lordship, there was no students, no
My lord.
enrollment, no teachers available, and even the construction of the school, lordship, may kindly peruse those photographs of the Xerox copy, lordship.
No, he already stated that
I have
that
already
day the school was not functioning.
And moreover, lordship, when there was a dispute in regard to this bias code, subsequently he has to apply for the.
my lord, that part is gone, my lord. It is they, my lord, who should have issued, my lord. From the, my lord, communication itself, it is very clear, my lord. Lordship will again kindly come to 96, my lord. 96, my lord.
And the name of the teachers has to be appeared in the DIAS, and the DIAS data after 2011-12 onwards. So that is also not there.
My lord, this DIAS data was blocked by the concerned authority, Sarvadesha authority, my lord. This is not my saying, my lord. This is the, my lord, stand taken by the district officer as well as the district mission coordinator.
No, no,
Nagaon,
that's
my
all right, but what is the environment that you have fill up the forms and sent it to the?
No, that environment is not there. I'm sorry, my lord. But otherwise, my lord,
Then
it should
how-
have been, my lord,
how the
released or
how
renewed,
the department is
freshly
issued
issued by the, my lord, mission director, my lord. Mission director did not issue, my lord. A fresh, neither it was, the earlier was not also released, my lord. Because of that difficulty, my lord, the dias, my lord, could not be continued. For that, my lord, I should not be held responsible, my lord. I cannot be held responsible, my lord. It is they who should have continued, my lord, either or to issue a fresh.
They have not issued, that's all right, but whether you have filed the particulars to the SSA?
My lord, I probably, my lord, the petitioner had applied before the concerned district officer and district mission
Not
coordinator,
probably. You
for
know
which, my
the-
lord, he has responded.
No, no, not probably or likely.
I'll get the
You
instruction.
produce the relevant documents before the court that you have applied for. And furnish the relevant particulars.
I'll produce it. Short date will, lordship will kindly fix.
Third, Sir Jay Ahmad, Lord at Council for the Sir Ian Thorman, Lord Instant for the respondent number.
One, two. 1, 2, and 6.
1, 2, and 6, and Mr. Chaudhary for 3 and 5. Which for 1? Oh, you are 1. Person to order. Dated 27/9/2024, Mr. Norma has produced the relevant photograph for this court today. During the course of hearing, Mr. Hamad made a statement before the court that Mr. Jay Ahmad, learned counsel for the petitioner submits that he will be granted some time to produce relevant documents to show that the petitioner has furnished the relevant particulars to the SSA for entering the DIAS data for the year 2011-12, no, 2010-11, 11-12, 12-13, 12-13, 13-14, 15, 14-15, and 15-16, and 16-17. There is according to allowed basis of the matter on when
My lord, on 18 or 19, my lord, next week, my lord. 20th, my lord. Tuesday.
Okay, in the meantime, Mr. Sorma will obtain necessary inspection as to whether the inspection was carried out by the who conducted. Who conducted the inspection?
Director, deputy director. Deputy director.
Whether the deputy director who had conducted investigation inspection as per order of this court had issued prior notice to the present petitioner about the date of inspection on next day.
Need the pieces.
Deeply obliged.
Need the pieces, Your Lordship.
Yes.
Pertaining to next matter, Your Lordship, since particular order, Your Lordship, last order, my name has been reflected. I have obtained the instruction.
Which matter?
Pertaining to item number 12. 12. That matter may get disposed of, Your Lordship. Your Lordship, I will not be able to attend the Act 12 at 2, Your Lordship.
Vendor, some of your colleagues.
I have given all the relevant documents.
There is one meeting open. We will resume at 2 o'clock.
That matter may get disposed of today.
No, we'll see.
Yes, Your Lordship.
This case also will recollect in the review petition number 1 of 25. That, what was that? No, 4. By this order, Lordship has recalled the order dated 10/12/2024 in WPC number 572 of 2024. Paragraph 7.
So what is your pair in this petition number 1?
There, for a direction to the respondent authority to finalize the tender and issue LOI.
Can such direction be issued by the court?
They have to finalize the tender, my lord. They are not doing that. I was found technically responsive and I was in the financial bit, I was found to be the L1. Then under clause 26.3, they have sought the justification for the unbalanced price, which I had submitted. So thereafter, they have only option to levy the additional performance security. At that stage, the writ petition came to be filed. That is WPC 752.
So your contention is that your technical bid is responsive and financial bid is responsive, and
And-
therefore a direction has to be issued
And L1,
to finalize the bid.
I'm the lowest bid. In the financial bid also, I was the lowest bidder. And under clause 20.
So maybe you may be the lowest bidder, but whether it creates an indivisible right in your favor.
Well, I have a right to know the melody. Result of the
No,
tender.
there is no doubt about it. You
So
have
there-
the right to know.
Lordship. So
But
therefore, the
whether
tender
it
has,
creates an indivisible right in your favor.
well, that is the my right, my lord, to know the result, my lord. The tender has to be finalized. Or they have a right to cancel. So for that purpose, my lord, they have to come up with the my lord order showing that the tender has been cancelled.
Yes, Mr. Tagum.
May I please, my lord?
Yes.
My lord, my learned senior has that he has a petitioner is right to know that page 134 of the petition, annexure D, that is the result of the financial bid. That is
134.
134. This is the result of the financial bid. That petitioner's firm have bid 9.04 below the NIT amounts.
Yes.
Accordingly, a notice was issued to the petitioner. That is next page, page 135. To give proper justification with standard rate analysis, petitioner was given notice that your financial bid is abnormally imbalanced, so you justified it. Then what was the petitioner justification?
Justification was made.
12 November 2024. He was given notice. The petitioner was given notice.
Then what happened thereafter?
Thereafter, the petitioner replied. That is page 136.
Yes.
Then he has, the petitioner has not replied what was sought for. But the petitioner simply stated that he has stock of TMT and he have ample machineries. The petitioner have ample machineries. He have materials available. That was not sought for. The item-wise rate was sought. His tender is below 19.4% below the bids amount, NIT amount. So accordingly, during this process was on, there was a one writ petition. That is writ petition 572. Then the authority was already has instructed that they are going for retender. Then that writ petition are accordingly disposed, which was reviewed by this honorable court. So otherwise also, the tendering authority was in the process of go for price tender. And it is, my lord, a settled principle, although that the bidders who quote highest or lowest, they cannot insist upon the tendering authority that his or her tender should be accepted. It is that cannot be insist. Now even the letter of acceptance also not yet issues. Only after opening of the financial bid, when the petitioner bid was abnormally low, then there was a cross funding to give a justification. That process was on. Then a writ petition by some other unsuccessful bidder was filed. Then verbal instruction was that they are going to go for a fresh tender. So there is
Mr. Tarak, whether you have taken any decision upon the so-called reply submitted by the petitioner?
that part have not, they have not. The representation which they have submitted is page 141. That is yet to be disposed of. So my lord may dispose this writ petition with direction that this is our representation may be disposed of. If they satisfy, they can go ahead with giving letter of acceptance. If they don't satisfy, the tendering authority have a discretion to go for fresh tender. Otherwise also writ court cannot interfere.
Well, that is his submission, my lord, but thing is that he has to produce the record and to show that the tender committee has taken a decision not to accept this particular rat analysis.
Such decision was not taken, he has submitted.
That's what, madam. That's what, madam. Now, what is the consequence of, my lord, seeking this rat analysis? That is given in clause 26.3, is at page 50.
No,
My lord, once
will not decide whether it is right or wrong. Let them take a decision. We will direct them to decide your representation and finalize the tender in whatever way they like.
No, my lord, at first, my lord, they have to, my lord, submit the, my lord, because Lordship has seen the various stages in the proceeding, my lord. At one point of time, it has been said that they want to resign the tender. So therefore, the writ petition was disposed of. Now, in the present writ petition, they have filed an affidavit incorporating an order of cancellation, wherefrom it appears that the tender has been cancelled.
Whether such a order is here.
Yes, yes, my lord. In the
Page
affidavit in opposition filed by the government at page 151.
151.
Madam.
It was rescinded.
Lordship, madam. At
Well, in
page
that order, they have
151.
When did you file the representation?
On a representation, I had filed, my lord, 23/12/2024.
Before
page-
this,
At page 141.
before this decision.
Yes, yes, madam. This is, my lord, only in the affidavit of this letter is of 31st of December 24. I have submitted the representation on 23/12/2024 at page 141. And the ground assigned in the order at page 151, Lordship will see, please refer to the Honorable High Court judgment by case number so-and-so dated 10/12/2023 regarding cancellation of all tender, as if by this Honorable Court, by the order dated 10/12, it has been, the tenders have been cancelled. Rather, Lordship had passed an order on the basis of the submission made by the, from the government side, and that they are taking a decision to resign the tender. This court did not cancel any of the tender, only endorsed the view of the submission made by from the government
that they are going to take a decision to cancel the tender. So therefore, a direction was issued to re-tender it. So that was, we have filed a review petition.
No.
So that has been recalled. Now, at this, so far as WPC number 1 is concerned, their pleadings are there. Now, so far as the second one matter, that is 572.
No,
Since
Mr. Trippier, this, if they have taken a decision to rescind the contract, but is it under challenge, this order?
this is,
It's
that's
not
what I'm
challenge.
saying, This was
This order 151 page number.
151. This is the,
Have you challenged this?
this is as if pursuant to the order dated 10/12/2023.
May not be, but
So
unless,
this order has been recalled by this court. This is non-est order now. This order itself has been recalled by this honorable court in the review petition.
My lord, since writ petition 572 is already recalled and the authority has referred this writ petition, so my humble submission would be that this will not relevant at this point of time. So his representation may be disposed of.
your representation is at page number
Page number 141.
141. Okay. Then, we will direct them to dispose of this writ petition
Before that,
without being influenced by any of the order passed by this court earlier.
the entire things have been already influenced. My lord, the submission that has been made recalling, my lord, rescinding the tender, etc. My lord. So therefore, Lordship would definitely like to see what is the decision of the tender committee. Now your Lordship will be, my lord, directing the authority to do that, my lord. But what the decision tender committee has taken, technical bid, I was found responsive. Financial bid, I was found the L1. Then pursuant to clause 26, they have sought the justification. I have submitted the justification. Now only option for them is left to issue the LOI and to impose additional performance security as per the clause, as per the bidding document.
No, that direction cannot be issued by this.
No, I'm not saying so. I'm saying what only the background of the case, and the referring to the clauses, this 26.3, what I'm submitting after seeking the justification of the red, the only option left for them to issue the LOI and they may impose a performance security, additional performance security.
Okay, let them take a decision in accordance with law.
Yes.
For that matter, I have to be heard by them.
Definitely.
Lordship. And these grounds are nobody's ground, This is the government has taken just now the grounds, So therefore, they will, if they have received any complaint or as such, what they are saying with regard to the writ petition, let them show cause as to why these two grounds they have assigned. The first ground is that my husband is the chief engineer of the one of the department.
No, that is in other writ petition.
That is other writ petition.
That is in other writ petition or other writ petition.
No, here also in the affidavit, same thing is there. They are showing their justification in the affidavit. They are taking the same ground. Firstly is that, my lord. And second one, they are trying to say that I have filed a false affidavit. Now, false affidavit, which one I have, it is already on record. Lordship will see whatever I have said. It's a correct thing. This,
let them take a fresh decision upon the representation filed by you, without being influenced by any of the observations made by this court, in accordance with.
Yes.
And in accordance with.
In that case, I may be hard and
Yes,
till then,
they will hear you.
Lordship, my lord.
Yes, Mr. Tarak.
Yes.
So before taking a decision upon the representation filed by the petitioner, you have to issue notice to him.
Yes.
You have to hear him.
Okay. Yes.
Only, and thereafter you have to pass the reason of the order.
My lord. Yes,
Is
my
it
lord.
okay to you?
Yes, it's okay.
Okay. Okay, then we are disposing of this petition.
And my lord,
And in respect of the other matter.
my lord, till then the status quo that may be maintained, my lord.
Definitely.
Lordship, because the order is already there, that may be.
That will be there. Till a decision is taken.
Till the decision is taken and communicated to me. So far as other, my lord, the writ petitioner perhaps is there, my lord, so he'll be submitting on the writ petition.
Petitioner, yes.
In
Yes,
my
Mr.
case, my lord-
Parme.
My lord, in my case, my lord, my humble submission would be let notice be go, my lord.
Pardon?
Let notice be go, my lord. Notice be issue, my lord, to the respondent, my lord.
Hmm.
Otherwise, my lord, alternative order may be passed, my lord, closing my writ petition, my lord, with a liberty, my lord. If the outcome of the representation in the other outcome of the disposal representation, my lord, goes against me, my lord, I may be allowed to file a new writ petition, my lord. That's the two options, my lord. I am
Okay, then we are closing this petition.
closing, my lord, and with liberty, my lord. Suppose tomorrow,
Okay,
my lord,
liberty will remain with you.
Yes.
Yes, Mr.
with
Secretary.
with a liberty, my lord.
Okay.
If my lord category, my lord, will mention the my lord. If the disposal representation by the authority in the of the private respondent, my lord, I will be give a liberty to file a
No,
press.
we
my
will
lord.
not mention that.
that-
But we will just grant the liberty to you to approach this court again if
If it is-
necessity arises.
Yes, that's. very
My lord, that will be done.
All right.
Obvious, my lord.
Item 6.
Mr. Dotto, you are referring to which part of this ROP?
Well, ROB page 299, my lord, that is with regard to, of course, my lord, the finance department, my lord. Where, my lord, the page 299. my lord, ROP.
Yes.
Where, my lord, it has been, my lord, payment 2, my lord, they've been granted. 299. My lord, Treasury accounts assistance with graduation qualification,
Page number 299.
299. my lord. Actually, it starts from something 280 or something, my lord. So, lord, finance department, my lord, lordship will say in between. The treasury accounts assistance with graduate qualification shall be paid as follows. Junior accounts assistant payment 2 with grade pay corresponding to 900. That is the only thing I find, my lord, with regard to finance department. Others, of course, I don't find anything, my lord, that
No, your prayer is for this advance increment.
no, my prayer is basically for, my lord, giving the graduate scale of
Yes, or graduate scale of
graduate
pay,
scale
yes.
of pay, which I say, my lord, as per the rules, it's 2003 rules. Their case is the notification, my lord. Notification was of 1993, my lord. That notification they say was withdrawn in 2011. But my case is on the rules, my lord. The rules clearly say that, my lord, those existing teachers who are having graduate, on the retirement of the graduate teacher will be upgraded. Now they are trying to distinguish and say that, no, since I came from an amalgamated school, therefore I'm not entitled to that. But there's nothing there which prevents me from being given the graduate scale, number one. Number two, I have come into the cadre, I have been absorbed. This is their stand. If your honor lordship looks at the order, impugn order, it says that I've been absorbed in the high school. The post, not just me alone, the post has been absorbed in the high school. Now the post in the intermediates in the ME school was of course of intermediate teacher, not of graduate teacher. But the post is absorbed in this school. Now, since I'm having the qualification as per the proviso, it says that those who are having the graduate scale will be granted graduate scale on the retirement or death or whatever, or vacancy arising of the incumbent teacher. Now, my case is that when Javed Ali was there, was a graduate teacher. He retired. So in his retired vacancy, I ought to have been upgraded. And in fact, after his retirement, I have been discharging his duties, the duties of the teacher with the graduate scale and teaching in the higher classes. Now, the second contention they raised was with regard to the rules. So they say the 2003 rules have been repealed in 2018. But Lordship will see, this 2018 3 rules came into effect only in 2019. It is not with retrospective effect. So therefore, whatever by rights which are accrued under 2003 rules cannot be taken away by saying that in 2018 the 2003 rules have been repealed. 2003 rules, 18 rules, Lordship will find at page 18 of the book. What my learned friend who was arguing the matter earlier had said that this has been 2003 Act rule is repealed. Understandable, this repeal. But the question is when it has come, 2018 rules has come into effect. The Assam Secondary Education Provincialized Schools Rules 2018. This starts at page 18. Now, Lordship will see page 18, bottom. Assam Secondary Education Provincialized School Rules, Service Rules 2018, bottom, my lord, published in the Assam Gazette Extraordinary on 10th October 2019. Now your Lordship will kindly turn to page 20. Short title, commencement and application. This, they shall come into force on the date of publication in the official gazette. So this rules comes into effect from 2019. So it is not given in retrospective effect. And it says, the repealing provision says, provided that all orders, the Assam section 35, page 48.
Yes.
The Assam Secondary Education Provincialized Service Tools 2003 order and notifications corresponding to these rules and in savings post immediately before commencement of the rules are hereby repealed. Provided that all orders made or action taken under the rules of so repeal or under any general orders ancillary thereto shall be deemed to have been validly made or taken under the corresponding rules provision to these rules. Now, Lordship will see this order of my amalgamation. This was passed in 2006 when the 2003 rules was there. There it was specifically mentioned, my lord, that it is without prejudice to my right, section 6, my lord, without prejudice to upgradation, page 19.
Yes.
But before 6, I'll place 2. That all the qualified staff of the ME school, madrasa, serving duly sanctioned posts shall be, it's wrongly said abolished, it should be absorbed in the amalgamated high school. So it's an absorption of the post with effect from the date of amalgamation with the respective pay and prospects, but with the amalgamated scenario list. Then 6, without prejudice to upgradation of scale of pay of teachers working at ME madrasa at intermediate scale of pay. So they will be entitled to upgradation if they possess the qualification. Of course, they have to possess the qualification. And my petitioner, he has he's an MA. So therefore, under the 2003 rules, page 366.
Yes.
Page 366. Proviso. Provided there shall be no fresh recruitment of to the cadres of junior teacher. I'm not a fresh recruiting. This is not a case of fresh recruitment. Provided there shall be no fresh recruitment to the cadres of junior teacher, junior classical teacher, junior Hindi teacher, senior classical teacher, and all such existing posts shall stand upgraded as graduate teacher or Hindi teacher, having bachelor degree from any recognized university or classical teacher, Sanskrit, Arabic, SMS language teacher, as the case may be, from the date such posts became vacant, either as a result of the retirement of the existing incumbent or otherwise. This is precisely my case. I have been absorbed from this elementary school, ME school to the high school. It's their order, it says I have been absorbed. In fact, in the impugn order also, they have said that I have been absorbed. Now, and the post, in fact, the post has been absorbed. Once it is absorbed, this 2003 rules become applicable to me. And this 2000 notification 2006 of amalgamation was passed after this, when this 2003 rules was in force. So therefore, I am not a fresh recruitee. And since I possess the qualification, on the death of Javed Ali in 2011, I prayed that I should be upgraded. That is my simple case. Now they are referring to a notification. Can the notification supersede these rules? And this notification was withdrawn in 2011, not before I joined or I was amalgamated. This was taken away in 2011, not in 2006 or 2005. And when 2003 rules is very specific, because I cannot be without any post, I cannot be hanging in the air. Once the school is amalgamated with the post, I automatically become I'm born into the cadre of the secondary school. And in the secondary school, there is a cadre of junior teacher also under 2003 rules. But they say, henceforth, there will be no further recruitment. And those having graduation will be absorbed when vacancy arises in this graduate scale. So therefore, to say that, therefore, my case is not a case of fresh recruitment. They are trying to say that there is no, these posts are only to be filled up by a fresh recruitment. No, in my humble submission, 2003 rules has made this provision that the existing teachers, though receiving intermediate scale, but having graduation as a degree, will be entitled to be upgraded on the vacancies arising. It may be case of death, it may be case of a retirement or resignation or whatever. So once the vacancy of graduate teacher arises because of such eventuality, the post is to be filled up by, or rather I am to be upgraded to that post. That is my case. So therefore, all these 1983 rules that being repealed in 2011 cannot supersede these provisions of this 2003 Act. And as I will just place one small judgment of the Honorable Apex Court, unless the statute of 2018, now 2018 statute has been said that is to repeal, unless the statute has a specific provision that it is to have a retrospective effect, it can only have a prospective effect. This was a case where the person concerned, there were some tenancy issues, whether they continue to be tenant under the old act or the new act, which came in between. The court said no, they have to be taken as tenant under the old act. Paragraph 22 and 22, I'll just read. Paragraph 21 and 22. 21, second paragraph, statutory laws. Last but one page, my lord. Last but one page.
Yes.
Statutory laws operate from the date of their enforcement, that is, prospectively. In case the legislature intends to make a law retrospective, then such an intention of the legislature must be shown clearly and unambiguously in the statute itself. So, my lord, as I have shown from the 2018 rules, it came into effect from 2019, and it says it will come into effect from the date of publication in the official gazette, not after that or not before that. Now, in paragraph 22, in this, since I was saying that it was whether it would be tenancy under the old act or new act, in view of the above, we hold that the so-and-so, the appellants jointly inherited a tenancy from so-and-so in the year 1970. Thus, the impugned judgment is liable to be set aside, as the appellant's tenancy did not expire in 2006 by the introduction of the 1977 Act. In the absence of clear and unequivocal intention of the 1997 Act to have a retrospective operation. So 2018 Act, in my humble submission, does not have a retrospective operation. It was not the intention of the legislation. It was not the intention that this Act has to come into force from a prior date. It is very specific. It will come effect from the date of publication, that is 1/1. Yes, 10/2019. so far as their affidavit is concerned, my lord, that affidavit is contrary to what the law says. They have not touched a single, touched a single thing about the law. They're trying to circumvent the law by taking the via media notification. They have not disputed the fact that I am working as that I have made a very specific statement in my paragraph 15, that I am discharging the duties in the higher classes, that of a graduate teacher. That has not been disputed anyway. So therefore, in my humble submission, the other judgment also I have referred, my lord, placed before lordship, my lord. Since I am, my lord, made to discharge our duties in the higher post, my lord, even in the temporary capacity, I have not been regularly promoted, my lord. I am entitled to that scale, my lord. So therefore, in my humble submission, my lord, the notification, its withdrawal in 2018-11 of 1993 notification and its withdrawal in 2011 will have no effect at all. I am governed by, my lord, the provisions of 2003, my lord, Act, my lord, where the proviso covers my case.
For the first time, I have heard about the 2003 rules. Earlier, my lord, this whole petition was structured and founded under this notification of 1995 and the 2011, my lord. In fact, my lord, kindly see the prayer. Prayer made in the petition is to set aside the notification of 2011, whereby the notification of 1993 was withdrawn, my lord. For the first time, my lord, my learned friend is relying on these 2003 rules. Therefore, my lord, in earlier occasion, when we have filed our affidavit, we have only limited our stand to the pleadings made in the petition.
My learned friend is perhaps not read paragraph 14 of my pleadings.
Now, my lord, coming to the application of rule of 2003, my lord, this proviso is not yet applicable to client of my learned friend, my lord. Kindly come to the page 367, my lord. The proviso to the rule 3, my lord. Not yet applicable to my learned friend, my lord.
Yes.
Provided that there shall not be no fresh recruitment to the cadres of junior teachers, junior classical teachers, junior Hindi teachers, senior classical teachers, and all such existing posts shall stand upgraded as graduate teachers or Hindi having bachelor degree from any recognized university, or classical teachers, Sanskrit, Arabic, Assamese language teachers, as the case may be. From that post, such posts become vacant. So, my lord, there shall be no fresh recruitment with regard to those posts, my lord. And those posts were upgraded to graduate when it fall vacant, my lord. Either as a result of retirement of existing incumbent or otherwise. So, in case of the petitioner, my lord, he was initially appointed as intermediate teachers in an ME school. That school was subsequently amalgamated with an high school, my lord. So, how this provision is applicable to him, my lord? This is a provision in respect of junior teachers, then my lord, senior classical teachers and junior Hindi teachers. These posts shall not be filled up. Once it is vacant, my lord, it shall not be filled up by fresh recruitment. It shall be treated as graduate teachers. Once the incumbent who are serving those posts will be upgraded to graduate posts, graduate teachers. So he was initially appointed in intermediate scale in a ME school. Thereafter, that school was amalgamated with the high school. So these provisions is not applicable to the petitioner. This is it. These posts which are already existed in his high school as junior teachers or junior classical teachers or junior Hindi teachers or senior classical teachers. This is not talking about any post held by a person in an intermediate scale in a ME school that subsequently amalgamated with the
high school, my lord. So this is not applicable, my lord. And as regards the entitlement of graduate scale, my lord, there is a judgment from this honorable court, my lord. Once a person entered into service in an intermediate scale, in spite of having his qualification of graduate, he is not entitled for graduate scale. Today, unfortunately, that judgment could not have me, my lord, but I can produce it, my lord. There is a case of Gauri Prabha Mohanto, my lord. In that case, my lord, it has been held that if a person initially appointed in an intermediate scale, subsequently, although he acquired graduate qualification, but is not entitled for graduate scale already.
But whether the facts of those that case is similar to the present case.
Yes, my lord, that I will produce, my lord. My lord, maybe one day time I can produce it. Today, in fact, midst of a hearing, I have entered, my lord. So, my lord, may fix up to next Monday or Tuesday, my lord. I'll produce that. But this.
But I am aware of that judgment, but Mr. Dotto also must know about it.
Yes, my lord. In fact, he can also go through it, my lord. It's a Gauri Prabha Mohanto. It can report not reported. Not reported. Not reported. As per my knowledge, it's not reported. I'll obtain a copy, my lord, and I'll give me a copy also. As regards that, his whole argument is based on the 2003 rules. But this proviso is not applicable.
So when you have obtained the graduation?
I am an MA of 1988, much before joining service.
He entered his initial entry to the service in intermediate.
Yes, because in that ME school, it was an intermediate course. I'm not disputing that. The factual issues are not in dispute. But what my learned friend is trying to say, the impugn order says, in fact, my amalgamation of the post is absorbed. So it is absorbed in the secondary department, number one. My learned friend has said that I have not made any reference of the rules, my lord, 2003 rules. Paragraph 14 is very specific. I have very specifically said, my lord, 2003 rules, my lord, under 2003 rules, I'm entitled, my lord. So to say that I'm raising this issue for the first time, and law point I can raise at any point of time, even otherwise, my lord, I've specifically raised page 6, my lord, page 14, sorry, paragraph 14. Specifically said, my lord, that 2003 rules is applicable.
In case, my lord, the language of 2003 rules is very clear, my lord. It's regarding junior teachers. No fresh recruitment will be done, my lord. Those posts will be subsequent. For vacant, my lord, it will be upgraded to a graduate teacher.
That is what I'm also submitting. My learned friend is submitting. I'm saying I'm not a fresh recruitment. It's not a question of fresh recruitment at all. It's a question of existing post which has been absorbed, and that post is to be upgraded on the death of the incumbent. I'm saying that's what I'm saying. I'm not claiming from the first day when the school was amalgamated. I cannot. That is why I'm saying on the death of Javed Ali in 2011, I'm entitled. That is the crux. Had I claimed from 2006, things would have been different. I'm not claiming from 2006 because of this proviso that once the vacancy occurs, this post, they will be abolished in a phased manner. And these persons will be, if they're having the qualification, they'll be absorbed given the graduate scale. That is what it's all about. It is not a case of fresh recruitment at all. I'm already there in the service of the department. It is for their administrative convenience. They have amalgamated ME schools and the high schools. Now, can it be to my detriment? And their own rule says, when vacancy arises, okay, these people will remain to be intermediate, but when these vacancies arise, we will upgrade them, but will not make any fresh recruitment. No fresh recruitment of junior teachers will be made. My case is not that of a fresh recruitment of a junior teacher, junior Hindi or Arabic teacher, or intermediate teacher, as they call it. My case is that of absorption of the intermediate teacher. So therefore, I am born into that cadre. Impugn order is very specific that the post has been absorbed. Page 25, in between, about 1, 2, 3, 4, 5, 6, 7, 8 lines from the top. Findings. And this finding is on the basis of records. On the perusal of records in hand, it transpires that Muhammad Abdul Jalil had retired, herein referred to the petitioner, was appointed as Arabic teacher in the intermediate scale of pay in the year 1977 in so-and-so school
He was transferred to so-and-so school, madrasa, thereafter to so-and-so madrasa. Thereafter in 2001, he was again transferred to Naitor ME Madrasa, Konapur. It also reveals that Naitor ME Madrasa was amalgamated to Fakhruddin Ali Ahmed High School, Naitor, in the year 2006. And the post of the petitioner was absorbed in the FA Ahmed High School. So therefore, the post was absorbed. And so far as my qualification is concerned, my lord, I have placed my MA, my lord, certificate. So I made a mistake, but it's in 1992, my lord. 1992, before the amalgamation, page 18. I completed MA in 1992. And so far as the graduation is concerned, I completed my graduation BA in 1990. So therefore, when the school was amalgamated, I was definite, because in the MA school, the post was definitely an intermediate teacher. That post was absorbed into the high school. And when the vacancy arose, that is the date I prayed for my upgradation, not prior to that. I could not have asked for upgradation from 2006, just because I'm a graduate. I only prayed for upgradation in terms of the proviso that no further recruitment will be made, but then this post will be upgraded. That is what the proviso clearly says. Now they are trying to make a distinction that I have come from the ME and this and that. That is not where what it says, the law says. It says whatever posts are there, we will not make any fresh recruitment of junior teachers, but we'll upgrade those posts with qualification. And my lord, what my learned friend was saying was Gauri Prabha, if his submission is right, my lord, that is a subsequent qualification being obtained. And that is not,
No.
I've not gone through. But what you are saying is that that person obtained qualification subsequently.
No, not subsequent. Prior to that.
And I'll have to go through that. I have not, because it's some report decision, I've not got.
But the fact is that in that case, the petitioner was serving in madrasa. In the 1993 notification, madrasa word is not there. Only provincialized high school and higher secondary school. Therefore, the court held that since the word madrasa is not there, so this notification will not cover the case of the teachers who were serving in madrasa. That was the finding.
Because my claim is not on the basis of notification. My case is based on 2003 rules. I'm asking for setting aside because this notification could not have been brought into the picture. This impugn order has been set aside. I'm praying for setting of the impugn order, Miller. Impugn order refers to this notification 2011 discontinuation. That is another aspect of the matter, whether it could have been done with retrospective effect, but that is not my case. My case is 2003, when the 2003 rules is existing, that squarely covers my case, and the notification cannot supersede the rules.
Okay. Yes, Mr. Khatania, you produced the judgment that.
Immediate on next.
Mayor, we'll keep the matter as further.
Minor, definitely. Lordship has given so much of time.
To learn a council for the petition. That Mr. Khatania for respondent authorities. This the matter is further on
Next week, evening.
hearing.
27th March.
27th.
27th.
Thursday.
Smile.
Oblige.
Oblige, Lordship.
Next slide.
Item 12.
Make the cases, Your Lordship. Here, Your Lordship, instruction has received today that proposal from the Director of Secondary Education, Assam, had been received, and this department has processed the proposal for release of arrear salary in respect of the present petitioner, Your Lordship. And she is in post of additional teacher contractual of Parhali High School under Kamrup District by under head account 2202 201. Your lordship number has been given for the year of 24 to 25. Now the concurrence of finance department is required for Royal, and the proposal is ready to be uploaded on reopening of the portal by the finance department. I would like to place this instruction. And also, the petitioner name has been reflected, your lordship, area budget allotment. That also, your lordship, I would like to submit.
So when the portal will be reopening? Reopening?
Finance.
Active. Instruction. So whether it is uploaded or not, you are not sure.
This is the latest instruction I have received. So your lordship, time frame may be given, your lordship, with a direction, your lordship.
No.
When we can confirm that it has been uploaded, what on the basis of the number, and we can verify.
Yes, madam.
Yes. কিমান দিন লাগবে?
Third Miss N.S. Thakuria, Learned Counsel for the petitioner, and P.S. Das, Learned Standing Counsel for the for this. This does produce a written instruction before this court and submits that the department has agreed to release the area salary in compliance with the order of this court, and that the proposal from the Director of Secondary Education has been received, and the department has processed the proposal for release of the area salary. And concurrence of Finance Department is required for Royal, and the proposal is ready to be uploaded on reopening of the portal by the Finance Department. And as such, this does submits that this writ petition may be closed by directing the respondent authorities to make necessary arrangement for payment of the amount within a time frame. Taking note of the submission of Learned Counsel for the counsel for both the parties, it is provided that Ms. Das Learned standing counsel for the respondent authorities shall obtain necessary instruction as to whether the proposal is uploaded in the website or not, or in the portal of the finance department or not. List the matter on
28, sorry, 26 March.
26 March.
Lordship, direction may be given, your lordship, the finance department, whether that portal has been opened or
No,
not.
first you have to ascertain whether it is uploaded or not.
Yes, your lordship, that instruction, I will.
Yeah.
My lord, can it be on 25th?
25th.
25th.
Okay.
Whether that is uploaded or not.
Okay. Okay. This is the matter of 25th. The instruction obtained by Ms. Das and furnished before this court
25th.
shall be part of the 25th.
Obliged, my lord.
Deeply obliged.
Item 13,
This matter related to enhancement of pay and challenging the order by which his pair for enhancement was rejected. In last occasion, the court, after hearing the matter, has directed to him the case before the
What is
court.
the record?
Yes. This little record was all from my lord, record was so voluminous, my lord, so my lord, sometime maybe, and so that I can go through that. Record is so voluminous.
No, you are not supposed to go the entire record, only the relevant pages.
Only they have to see the inquiry report. And as that custom, after long procession, at least I am happy that the record has come. At 3 occasions, the court directed him to present. And the matter record is come today. So she recorded that the record is come and fixed on 20.
On?
Thursday, 20.
Next Thursday.
On next Thursday.
Okay.
On 20.
Heard Mr. P.P. Borwa, learned counsel for the petitioner. And also heard Mr. U. Sharma, learned counsel for the respondent. Respondent authorities. Mr. Sharma submits that he has received the record, which is voluminous, and he begs for granting him some time to go to the same. Here it is allowed, let's list the matter on 20th. 20.
20. Obliged.
item 14 and 51.
Maybe.
Only 14.
Only 14, yes. Yeah, only 14. My lord, in the earlier round of litigation, my lord, this honorable court, while disposing the writ petition, my lord, has made an observation. Page 34 is the order of the earlier round of litigation. On that day, my lord, I take your lordship, a communication has been submitted on behalf of the government to the court, my lord. It is recorded at paragraph 5, page 36, my lord. The government has decided to, my lord, it is quoted, communication dated 24/8/2010. With reference to the above, I am directed to say that as per record, these 22 numbers of music teachers were appointed on ad hoc basis without following the rules or legally furnishing of procedures. Hence, they have no right to claim for the post at all if vacancies are there. We may take steps to fill up the post in question in accordance with law. These 22 numbers of incumbents may also be allowed to participate in the normal selection process by condoning overage if required. They may, however, be given some weightage for their past services. If any of them have been working or have worked during the period, salaries be admissible may be paid to them, but question of further continuation of or regularization does not arise. In case any one of them is still working, his service should be forthwith dispensed with. This is the direction given by the government in the year 2010 in respect of 22 numbers of teachers, my lord. And next paragraph. A reading of the communication of 24/8/2010 indicates that there was a decision of the government of Assam in respect of 22 numbers of music teachers appointed on ad hoc basis without following the rules to give them the benefits of an opportunity of participating in a normal selection process by condoning their age, to give weightage of their past service in the event of such participation, and to pay the salaries and allowances for the period for which they have been working or they have worked. In other words, the said communication also provides that even if the 22 music teachers have not continued their services but had worked in the past for a given period of time, their salaries for the actual period for which they had worked should be paid. Such and such Learned Standing Council for the Secondary Education Department has produced a communication dated 27/12/2012 from the Deputy Director of Secondary Education addressed to the husband of the petitioner under RTI Act of 2005, which gives a prima facie indication that petitioner was also amongst the 22 music teachers referred in the communication dated 24/8/2010. In the said circumstances, this court is of the view that the communication dated 24/8/2010 from the Undersecretary to the Government of Assam, Secondary Education Department to the Director of Secondary Education Assam, gives a legitimate expectation to the petitioner that her case would also be considered in terms of said communication dated 24/8/2010. The communication of 24/8/2010 having conveyed a definite decision of the Government of Assam in the Secondary Education Department that the aforementioned three benefits would be given to the 22 numbers of 22 music teachers. Therefore, it cannot be stated that the expectation of the petitioner was merely an anticipation. On the other hand, the said communication entitles the petitioner to a definite legal right to be considered in the matter it was provided therein. In view of the above, this writ petition is disposed of by directing the Commissioner and Secretary to the Government of Assam in the Secondary Education Department to give a consideration to the claim of the petitioner for the aforementioned three benefits contained in the communication dated 24/8/2010. In doing so, the Commissioner and Secretary shall firstly ascertain on facts as to whether the petitioner is included amongst the 22 music teachers referred therein. In the event it is found that the petitioner is in fact included amongst the 22 music teachers, further consequential action shall be taken, that is giving an opportunity to the petitioner to participate in the regular selection process by condoning her age and further giving weightage to her past service. Further, the salary of the petitioner for the period for which she had actually worked and rendered her service shall also be paid in terms of the communication dated 24/8/2010. My lord, this is the direction in respect of the 24, this is a decision actually by the government in respect of 22 numbers of music teachers. But after the disposal of this writ petition, my lord, I take your lordship to page number 44, Annexure 5C. The director has submitted a detailed status report in respect of these 22 numbers of teachers. And your lordship will find in the order dated communication dated 2010, the government has directed them to release them and dispense, my lord, from the service. But, my lord, what happened in the page 45, your lordship will find the status of the teachers, including the name of the petitioner at serial number 20 and serial number 11, that my lord Ranjita Devi, my lord teacher. Everyone is working, my lord. Everyone is getting salary, whether receiving salary or not. Yes. And in respect of the, my lord petitioner, serial number 20, it is written, terminated from service as reported by IS Kamrup. Whereas there was no termination proceedings, nothing in respect of the petitioner.
There is no termination. order.
No proceedings at all, my lord, no shock cause, nothing with regard to the petitioner, my lord.
No, tell me, there may not be any show cause notice, but is there any termination order?
No. There was no termination order communicated to me till date. And this honorable court, my lord, meant my lord, in respect of 22 numbers of teachers. The direction given by this honorable court, my lord, it's clear that you pay the benefit for whatever period they have served. And you, the honorable court has, my lord, presumed that the 22 numbers of teachers have already been terminated. So let them, my lord, be included in the selection process also. But in fact, the reality is that, my lord, nobody is terminated. Everybody is getting their salary regularly, my lord. And I was the only person, my lord, who has been stopped like a maid servant of the house, my lord, not to, without any, my lord, issuing any order. Just you don't come from tomorrow. And your lordship will take, my lord, to page number 57. Serial number 11, this is Srimati Ranjita Sharma. She has approached in the year 2011, my lord.
Yes.
I read, my lord, page 58, my lord. The grievance of the petitioner in the present petition is that though she was appointed on 24/1993 by the Director of Secondary Education initially for a period of 3 months, pursuant to the decision taken by the respondent authority, she appeared in an interview for regularization of her service, and accordingly she was allowed to continue as music teacher in Nalbari Girls High School. According to the petitioner, her salary, however, has not been paid from the month of February 2011. The petitioner therefore has claimed the salary from the month of March 2011 in present writ petition. Such and such learned counsel for the petitioner, based on the aforesaid facts, has submitted that since the petitioner is continuing as music teacher and her salary was paid up to the month of February 2011, the authority cannot, without assigning any reason, withhold the payment of the monthly salary of the petitioner as she has done in the as has been done in the instant case. Mr. Goswami Learned Standing Council, Education Department, as well as Mr. Gogisan Finance Department, apart from Mr. Talukdar Learned Standing appearing for the respondent number 6, on the other hand, have submitted that there was a process initiated for regularization of services of certain teachers, in which process the petitioner has participated. It has, however, been submitted by Mr. Sansa Learned Standing Council appearing for the respondent number 6 that the petitioner was not selected for regularization in service, and as such she cannot as a matter of right claim the payment of salary. The Learned Standing Council at Education Department, however, could not place the relevant records before this court today as to ascertain as to whether the selection process conducted in the year 1996, the petitioner has been selected for regulation in service, and hence no finding could be recorded in that regard by this court in the present proceeding. That being the position, the present writ petition is disposed of by directing the Commissioner and Secretary Education Secondary Department to consider the case of the petitioner for payment of the salary by making necessary inquiry as to whether the petitioner was selected in the process initiated for regularization in service. Before passing such order, the Commissioner shall also give reasonable opportunity of being heard to all the parties, including concerned departmental officer. The said exercise is directed to be completed within 2 months from the date of production of the certified copy of the order passed today, to be produced by any of the parties before the said authority. The writ petition stands disposed of. Following this order, my lord, there was, as per the direction of this honorable court, there was an inquiry in the department, and ultimately the order has been passed in the year in page number 61, my lord, by the director in compliance of this order. In pursuance of the government letter number such and such, and in compliance of the Honorable High Court's order dated such and such, passed in WPC number such and such, the services of Srimati Ranjita Sharma, music teacher of Nalbari Girls High School, Nalbari, is hereby regularized in the post of music teacher of the said school, created by number such and such, dated such and such, with effect, with immediate effect. This is issued with compliance of the such and such direction, madam.
My lord, my humble submission is that, my lord, the petitioner has been, my lord, deprived of the equal treatment. Because, my lord, she is included in the list of 22 numbers of teachers. And the state government during the proceedings in the year 19, the earlier proceedings, my lord, they have submitted that they have, my lord, terminated all the teachers. And presuming that, my lord, to be the true fact, my lord, this honorable court, my lord, has given the direction in the while disposing the order that you pay the salary and you allow them to participate by condoning them the age and the give them special weightage. But the reality is that, my lord, only the petitioner hereof has been, my lord, terminated, so-called terminated, my lord, and the others are continuing. Is an unequal treatment. While giving the affidavit in reply, my lord, to the affidavit opposition filed by my learned friend, my lord, I have annexed one judgment of this honorable court, my lord, wherein the honorable apex court order has also been annexed, and which says that, my lord, even for the contractual employees, if you go for terminating them, my lord, at least one opportunity should be given to present their case, my lord, before the authority.
Where is that judgment?
That is, my lord, at page number 91 in the 90, my lord, in the affidavit in reply, my lord. Here, some contractual employees, one contractual employee of the Panchayat and Rural Development Department, my lord, she was terminated, a contractual employee, and it is interfered by this honorable court. Page number 99, my lord, is the paragraph 22 is the order, my lord. The state respondents are directed to reinstate the petitioner in service forthwith within a period of 15 days from the receipt of a certified copy of this order. Upon reinstatement, it would be open to the respondent authorities to proceed against the petitioner in accordance with law by serving proper notice indicating specific charges brought against the petitioner. In doing so, it would be open to the respondent authorities to place the petitioner under suspension pending trial and or conclusion of the departmental proceeding if so advised. However, upon suspension, the petitioner would be entitled to subsistence allowance. The respondent authorities are directed to strictly comply with the requirement of the provisions of the rules 1964, as well as the principles of natural justice. On completion of such inquiry, it would be open to the competent authorities to pass such appropriate orders as may be deemed appropriate. And, my lord, in the at page 98, paragraph 19, my lord, it is Honorable Apex Court's observation made in the AIR 1958 SC 36 has been quoted, my lord. In the light of the allegations on which the service of the petitioner has been terminated, the Honorable Supreme Court of India, in the case of such and such, reported in such and such, had already held that even for terminating a temporary employee, the principles of Article 311 of the Constitution of India was required to be complied with. Similar view of Supreme Court of India has also been expressed in such and such case. And whereas the petitioner was getting the salary, my lord, in the definite scale of pay assigned to the post of music teacher, as per ROP.
And which judgment of the Supreme Court relied upon in this judgment?
My lord, AIR 1958 SC 36 and, my lord, 1991 2 STC 636.
AIR
1958.
Page number?
SC, page 36. In my case, my lord, page number 98. Affidavit in reply, page number 98.
Which paragraph of the judgment?
Lordship?
In which paragraph of the judgment?
In 19, my lord, paragraph 19 of this, page 98, paragraph 19, my lord. My lord, last occasion, my lord, my learned friend has raised the issue that is barred by res judicata. But that is not applicable here because, my lord, the cause of action, my lord, arose from the judgment itself of the earlier proceedings. Because in the judgment, my lord, this honorable court has given certain directions considering the actual, presuming the actual fact, my lord, on the basis of the communication dated 24/8/2010. But when after the judgment, my lord, when the process has been initiated, my lord, that it is found that the report of the, my lord, Annexure 5C, when the report of the director has been submitted to the commissioner, my lord, page 44. It is in status report at page 45 gives the just opposite scenario, my lord. Just opposite. They have in the placed their case in the earlier round of litigation that all those have been terminated 22 teachers. So there will be a fresh selection, and in that selection they will be given special chance, special weightage condoning their age. But that is not the fact. Fact is that, my lord, only the petitioner hereof, without any process, without even issuing the order, has been restrained that you should not come to the school from tomorrow.
The Khataniya, whether the termination order is placed on record.
Here, my lord, kindly come to page 33. The order which is SL in this petition, my lord. Page 33. May I read the order, my lord?
Yes.
Seen and read the representation dated 4/9/2012 submitted by Mrs. Juri Borua, music teachers, Banikanto Memorial HS School, Rehabari, Guwahati. Also read the government letter number dated 24/8/2010. Mrs. Juri Borua was appointed as music teacher and posted at Mirza Girls High School temporarily for a period of 3 months or till the post is filled up by the selected candidate. On 21/6/1994, White Office Memo number so and so. Hereafter, her service was withdrawn from Mirza Girls High School, Mirza, and placed at Banikanto Memorial HS School, Rehabari, Guwahati, by memo number so and so dated 10/7/1994. The term of her ad hoc appointment was extended last for a period of 6 months with effect from 1/9/1994. And thereafter, her service neither extended nor regularized. So her service was not extended thereafter, my lord. Mrs. Juri Borua drawn her salary up to July 2001. Government letter number dated instructed the music teachers appointed on ad hoc basis without following the rule have no right to claim for the post at all if vacancies are there. Hence, the claim for regularization of the and payment of salary of Mrs. Juri Borua cannot be considered. The claim is rejected. She is not entitled to any salary. So her claim for regularization was rejected, madam. This order was assailed in writ petition. Madam, kindly come to page Case 35, my lord. The writ petition is 1004, 2013. Order dated 22/2018. The order of 2012, my lord, whereby her claim for regulation was rejected, is SL in this writ petition. May I read, my lord? Paragraph 2. The petitioner was appointed as a music teacher as per order dated 21/6/1994 of the Director of Secondary Education, Assam, and she was posted in the Mirza Girls High School. It is stated that the appointment was pursuant to selection and it was for a period of 3 months or till the post is filled up by selected candidate. Later on, her services were withdrawn from the Mirza Girls High School and she was placed at the disposal of the principal Banikanto Memorial Girls High School in Guwahati, and her posting was against a vacant post which was created, government letter number so dated 16/11/1991, which was subsequently been permanently retained by the government dated 17/11/2003. The service of the petitioner was extended from time to time, and she was paid her salary and other benefit up to 2001. Hereafter, although the salary and other benefits had been stopped, but the petitioner continued to work as a music teacher in Banikanto Memorial Girls High School, Guwahati, without any pay, and at the same time, the respondent authorities continued to avail her service as well. Thereafter, by an order dated 5/11/2012, the Director of Secondary Education, Assam, it was held that the petitioner is neither entitled to any regulation nor she is entitled to payment of salary and allowances. It was provided that in the said order that her services were not extended earlier, and further by the government letter dated 24/2010, it was provided that the music teachers appointed on an ad hoc basis without following the rules have no right to claim the post, even if the vacancies are in existence. The said order dated 5/11/2012 of the director has been assailed in this petition. The order I have referred in page number 33, which has been assailed in this petition, with a further prayer for a direction to the respondent authorities to pay the salary and other benefits to the petitioners from July 2021 onwards. Hereafter, paragraph 5. In the course of hearing, the communication dated 24/8/2010 from the Secretary to the Government of Assam in the Secondary Education Department made to the Director of Secondary Education, Assam, had been brought to the notice of this court. The said communication contains as follows. With reference to the above, I am right to say that as per record, these 22 numbers of music teachers were appointed on ad hoc basis without following the rules or legally furnishing the procedure. Hence, they have no right to claim for the post at all if vacancies are here. We may take steps to fill up the post in question in accordance with law. These 22 numbers of incumbents may also be allowed to participate in the normal selection process by condoning overage if required. Here, they may, however, be given some weightage for their past services. If any of them have been working or have worked during the period, salaries as admissible may be paid to them. But question of their further continuation or regulation does not arise. In case any of them is still working, a service should be forthwith dispensed. So, the reading of the communication dated 24/8/2010 indicates that there was a decision of the government in respect of 22 numbers of music teachers appointed on ad hoc basis without following the rules to give them the benefit of an opportunity of participating in a normal selection process by condoning their age, to give weightage of their past service in the event of participation, and pay the salary and allowances for their period for which they have been working. In other words, the said communication also provides that even if the 22 music teachers have not continued their services, but had worked in past for a given period of time, their salary for the crucial period which they had worked should be paid. So, my lord, now we can skip the paragraph 7, my lord. The ultimate paragraph at direction at page paragraph 8, my lord. In view of the above, this writ petition is disposed of by directing the Commissioner and Secretary to the Government of Assam in the Secondary Education Department to give a consideration to the claim of the petitioners for the aforementioned 3 benefits. Only 3 benefits have been given to the petitioners contained in the communication dated 24/8/2010. In doing so, the Commissioner and Secretary shall firstly ascertain on facts as to whether the petitioner is included among the 22 music teachers referred herein. In that event, it is found that the petitioner is included amongst the 22 music teachers. Further consequential action shall be taken, that is, given an opportunity to the petitioner to participate in the regular selection process by condoning her age, and further by giving weightage to her past service. Further, the salary of the petitioner for the period for which she had actually worked and rendered her service shall be paid in terms of the communication dated 24/8/2010. So, my lord, by this direction, my lord, the benefit mentioned in the like communication date 24/8/2010 was extended to the petitioner. But the impugn order, which I have referred in page 33, 5/11/2012, has never been interfered with, my lord. So now, my lord, kindly come to the prayer made in this petition. Page 22. Quashing and revoking the impugn communication dated 12/9/2023 issued by the office of the respondent number 2. Further, your lordship may be pleased to direct the state petitioner to allow the petitioner to resume her service as music teacher of Banikanto Memorial HS School by recalling the order of rejection of regulation of service of the petitioner dated 5/11/2012. This prayer has already been made in the earlier round of litigation that was rejected by this honorable court. Now, my lord, same prayer has been made in this petition.
One number.
His writ petition is barred by res judicata.
22-25.
So the other benefits given by the order dated,
That is, my lord. That is, my lord, if we have started any selection, in that case, my lord, it was directed, my lord. It is not that case, my lord, they will get this benefit. In fact, I have the record, my lord. From the record, it is in my lord, has not participated in the subsequent selection process. Not the record process. There is a communication of 15th of March 2018. May I read the communication, my lord? In respect of the writ petition 1004/2013. In inviting a reference to the above, I have the honor to state that Fairways comment of the aforesaid case already been submitted to the so-and-so. The services of 160 numbers of music teachers working in different high school of the state were regularized by office order number so-and-so dated 30/3/1996, a copy of which is enclosed herewith. The name of the petitioner is not figured in the aforementioned regulation order. Perhaps she did not appear in the interview for regulation of the service of music teacher, or she did not get any selection for the same. The service of the petitioner cannot be regularized without selection. And so, this is the communication of 2018, where there is a observation that she may not participate in the selection process. But as regards the direction issued in this order dated, 2018 order, my lord. In case of any selection process initiated by the department, then only this benefit of opportunity to participate in the normal selection process by condoning the age was given, my lord. But thereafter, my lord, no selection was conducted, my lord, as regards the music teacher. So naturally, my lord, she will not get the opportunity. There is no mandamus to conduct a selection process, give an opportunity to the petitioner in the earlier petition. There was no mandamus. If there was a selection process, in that case, she was allowed to participate by condoning her age and giving weightage for her person.
May I please? My lord, may I, once again read, my lord, order portion, operative portion, page 37. In doing so,
Mr. Professor.
yes, sir.
So this order, no, there's a pair.
Yeah.
In the present writ petition, was the pair in the earlier writ petition?
Earlier, my lord, it was for setting aside the, my lord, order it is such. Now, my lord, on the basis of this direction, consequential right has been accrued to the petitioner also, my lord. And therefore, the petitioner has the right to approach this honorable court also. Because your lordship will kindly peruse the, my lord, the operative portion of the order again, page 37. In view of the above, this writ petition is disposed of by directing the commissioner and secretary to the government of Assam in the secondary education department to give a consideration to the claim of the petitioner. To claim of the petitioner was, my lord, to set aside the impugn order, to give a consideration to that, my lord. For the aforementioned three benefits contained in the communication it is such and such. In doing so, the commissioner and secretary shall firstly ascertain on the facts as to whether the petitioner is included amongst 22 music teachers. Whether I'm there in the list of 22 teachers, that is to be ascertained first. In the event it is found that the petitioner is in fact included amongst 22 music teachers, further consequential action be taken. And after, my lord, asserting this list, my lord, in the of these 22 numbers of teachers, it is found that all are working. They have misrepresented, my lord, this department has misrepresented by issuing this letter that is not at all executed in terms of this direction of the commissioner by the director. The letter which is quoted at page 36, my lord, this is dated 24/8/2010, which says that 22 numbers of teachers, a perusal indicates that director has been given a direction that to terminate all the teachers, 22 numbers of teachers. But in fact, after the disposal of this writ petition, my lord, while the matter was brought to the notice of the department, my lord, the list was called for. And the list was when called for, my lord, it is found that 22 numbers have not been disturbed. Only the petitioner out of 22 numbers have been disturbed. Therefore, I have got the consequential right to, my lord, approach this honorable court, because the direction itself gives a consequential, my lord, follow-up that you treat them, my lord. It is found that if in the event it is found that the petitioner is in fact included amongst the 22 music teachers, further consequential action should be taken. What is the action taken in respect of the 22 numbers of teachers, my lord? They have been allowed to continue. Then why shall I not be allowed to continue, my lord? What is the difference between these 22 numbers and myself, my lord? The order of this honorable court gives me a right, further consequential right. And my lord, I place before lordship the latest judgment of the Honorable Supreme Court, my lord, passed on, my lord, 31 January 2025. With regard to the temporary employees, my lord, whoever, my lord, given the wages and whatever, my lord, even the contractual employees, there should not be, paragraph 18, my lord, kindly be perused, my lord. You cannot throw the employees, my lord.
Page number?
Paragraph 18, my lord, before the last page. The impugn order of the High Court to the extent by confining the appellant workman to future daily wage engagement without continuity or meaningful back wages is hereby set aside with the following directions. The discontinuation of the appellant workman's services affected without compliance with section 6E and section such and such of the Such Act is declared illegal. All orders and or communications terminating their services are quashed. In consequence, the appellant workmen shall be treated or continuing in service from the date of their termination for all the purposes, including.
Where is the ratio of the case? These are the reliefs granted by the Supreme Court to the.
My lord, they have been allowed to continue. They should be reinstated immediately, my lord, and the gap period 50% wages should be given.
Where is the ratio of the case?
Ratio, my lord. It is given on the basis of the, my lord, earlier judgment of the Honorable Supreme Court, my lord. It is quoted there itself, my lord.
Where?
I am giving, my lord. Page, it is paragraph, my lord. Page 18, my lord, Joggu versus Union of India, paragraph 22 is quoted, my lord. Earlier Supreme Court judgment. If the ratio of the case is that if the employees are allowed to, my lord, either on contractual basis or on temporary basis if they are allowed to work for a longer period of time and they are discharging their duties like a permanent employees, my lord, they should not be, my lord, deprived of the equal benefits from the that is given to the permanent employee.
Okay.
My humble submission is that, my lord, I have made a representation after that, my lord. In the representation, I made two things, my lord. Either allowed me to continue to serve as like other 21 numbers of teachers, or, my lord, grant me the pensionary benefit by regularizing my service with effect from the date of my last salary, my lord.
Where is that representation?
It is there, my lord. Page 48, annexes. My lord, page 53, annexer 9, my lord. Because I have rendered sufficient period of service, my lord. I have now I am overaged. I cannot go for a new job. And my colleagues who have been appointed along with me, my lord, they are enjoying the everything. Some of them retired and got the pension also.
Mr. Khatuniar, can it be said that Rajya Vikata is applicable here in this case because in the order of this court,
Yes, ma'am.
the prayer of the petitioner is exactly not rejected.
No,
There
ma'am.
was a direction to the
Yeah,
director to give consideration.
If consideration on the basis of some communication, my lord. So, my lord, the prayer for regulation was not considered. Prayer for regulation, her, because by the impugn order of 2012, her prayer for regulation was rejected by the department. She has said that in the writ petition. That writ petition was, in that writ petition, direction was issued on the basis of some communication. But her prayer for regulation was not interfered with by this honorable court. And this direction, my lord, there are only 3 conditions are there. An opportunity of participating in a normal selection process by condoning the age. If the department started a process for regular selection, then she will be given the opportunity to participate in that selection process by condoning her age. And secondly, my lord, to give weightage for that her person. And as regards the pay and salary and allowances, that has already been taken care of. She has been given the payment of salary and allowances for the periods she worked, my lord. So her prayer for regulation was rejected. Now, my lord, kindly see the prayer. The same prayer, my lord. Same prayer. In that petition, perhaps she used the word setting aside. Now she has used the word recalling, my lord. Nothing else, my lord.
But that has come.
To resume her service as music teacher of Banikanta Memorial High School, Guwahati, by recalling the order dated order of rejection of regulation. So, the order of rejection of regulation means in earlier round of litigation, which has challenged, my lord, that has not been granted. Therefore, she, because without cancelling that order of cancellation of regulation, she cannot enter into the service, my lord. Because there is an order in force whereby her regulation was rejected. So without interfering with, my lord, she cannot get back to the service. That is why, in other way, this prayer has been made, my lord. That is why, my lord, this is barred by principle of res judicata.
Okay, we will examine that.
My humble submission after to his reply, I'm giving reply, my lord,
Hmm.
because that observation, my lord, has come from the court only because of the misrepresentation made by them, not on the basis of this merit of the case, my lord. They have submitted a communication which has not been at all acted upon. They have presented the case that we have terminated 22 numbers of teachers. On the basis of that, the honorable court has come to the finding, as we have terminated all, they give them salary. But in fact, when the inquiry report has come, my lord, after passing of this judgment, it has given that only the petitioner has been terminated, my lord, others are allowing and enjoying their all service benefits.
Hmm.
And this honorable court has given a rider to the petitioner, my lord, while passing the judgment, my lord.
Hmm.
There should be at least equal treatment should be made to the 22 numbers of teachers. Therefore, it is not barred by res judicata, my lord. It's my humble submission.
So, Mr. Khatania, why similar order should not be passed in this petition also?
What similar order?
That order by which one of the music teacher of the amongst the 22 candidates was regularized?
Ranjita Sharma, my lord.
Yes.
In case of Ranjita Sharma, my lord, can you see the direction at page 59? That being the position, the present writ petition is disposed of directing the Commissioner Secretary, Education Secretary Department to consider the case of the petitioner for payment of salary by making necessary inquiry as to whether a petitioner was selected in the process initiated for regulation of in service. Because here in the case of petitioners, my lord, in respect to this petitioner, she did not appear in the selection for regulation of service, my lord, because I have already read out the letter of 2018. That in that letter, it is clearly mentioned that she was absent for that selection process. Secondly, before passing such order of communication, commissioners shall also give a reasonable opportunity of being heard to all the parties, including the concerned department of the state is likely to be completed within 2 years from date of production of the certificate copy of the order. So, there is a simple direction whether she was participated in that selection or not, my lord. And in the case of this petitioner, my lord, in fact, I have the record, my lord, where it mentioned that she did not participate in that selection.
No.
If she did not participate, my lord, how can she claim the benefit of given to Ranjita Sharma? That this issue has already been decided by this honorable court in the earlier order.
This order is passed on, my lord, 2012 in case of Ranjita Sharma, my lord. And that on that day, my lord, page number 88, my lord, it is clearly stated the Learned Standing Council has failed to produce the documents with regard to the selection, and how my learned friend has come to the conclusion that I did not participate at that point of time, my lord.
I have a record, my lord, that is why I'm saying, my lord. I cannot say from my own.
Whether that has to examine.
He can examine, my lord. I can give him.
This is the letter only, my lord. This is the letter. This is not the selection, tabulation of the marks and nothing. It's only letter.
Select this is there, my lord.
In this case, তার নাম নাই। Ranjita Sharma নাম নাই। My lord, in this list, my lord, the name of Ranjita Sharma, whose service has been regularized, her name is not there. That list is with me also. What my learned friend is produced, that is provided by me, by the department, through RTI. In that list, the name of Ranjita Sharma is not there. Her service has been regularized.
My lord, perhaps he is arguing the case of Ranjita Sharma.
I am not arguing the case of Ranjita Sharma, my lord. Unequal treatment done to me, my lord, that I am submitting.
She cannot be granted negative equality, my lord.
Out of 22 numbers of candidates.
In this list, my lord, name of petitioner is not present.
Negative equality, but as per order of the court. There is an order of the court.
Yes, my lord. There is an order of the court. After that, my lord, the Ranjita Sharma's case was considered. But as regards the list is concerned, my lord, in this list, her name is not there, my lord.
Name of Ranjita Sharma is not there. I am submitting with.
in that this is a case of negative equality, my lord.
Out of,
If wrongly the benefit was given to Ranjita Sharma, that doesn't mean the petitioner will also get the same benefit, my lord.
this is not, my lord, negative equality, my lord.
Whether any such environment is there in the, in your writ petition? No, in your affidavit in opposition?
My lord,
Nothing like
in
that.
affidavit in opposition, in fact, we have not stated about Ranjita Sharma, my lord.
So in order to claim negative equality, first you have to admit that you have committed mistake. By mistake, you have given some benefit to some other person. Only then you will be entitled to claim negative equality.
Because now now I'm from the record, I'm saying that her name is not in the list. Now she's arguing that
The record,
the name of Ranjita Sharma was not
You
there.
furnish the record.
That is why I'm saying that it's a case of negative equality.
Let you
But it is
furnish
not her case also, my lord.
furnish the record to the
Yes, ma'am.
master.
obliged.
Heard Mr. Putesto, learned court of for learned of the court of respondent authority. Yes, madam, you have a?
Yes.
5. Okay. That's perfect. Any submission? No. Argument concluded. Judgment is there.
Obliged. Obliged.
Item 15.
May I please look? My lord, kindly have a look the earlier order passed by this honorable court. This matter is connected with my lord, item number 51, contempt petition, my lord. This petitioner filed 2 petition, my lord, 1 contempt and 1 writ petition, my lord.
This is regarding releasing.
Yes,
of
my lord,
arrears salary.
overstay period, my lord. Following the, my lord, judgment of the Honorable Supreme Court, this Honorable Court, my lord, already passed detailed judgment, my lord, that, my lord, overstay periods, my lord, recovery is not necessary, and it was provided to give the, my lord, pension from the actual date of retirement, my lord, with area pension, etc., my lord. Because there is a, my lord, principle is that, my lord, as per the judgment of the Supreme Court, my lord, he worked, pension is already he is entitled. And in the meantime, my lord, he worked and he got the, my lord, remuneration, my lord. This is the principle. But here, my lord, in spite of this, my lord, the specific judgment already quoted in the last occasion by this honorable court, and in the writ petition, my lord, page 34. And in spite of this, my lord, specific direction and observation of this honorable court, my lord, he made one communication that, my lord, salary cannot be, area pension cannot be granted like that. Page 34, my lord, direction part. It is already quoted, my lord, earlier.
Yes, Mr. Nath. Well, kindly come to page number 34. He's relying that. Well, his prayer is basically that for release of, kindly see first page number 8 of the writ petition. Well, I'm appealing for the respect. The director pension. Kindly come to page number 8. His prayer is, why appropriate writ order or direction shall not be issued directing the respondents to release the arrear pension of petitioner from 1 to 2018 to 36/2021 by modifying the order dated 11/5/2020. Well, his basic claim is for 1 to 2018 to 36/2021. He overset for that period. Now kindly come to page 34. This is the direction. Page 30. Page 34. The judgment of the Honorable Court starts at page number 20. This is the operative portion. Page number Yes, yes.
para 20.
Paragraph 20.
Look.
Consequently, this court therefore disposal of both the writ petitions with the following observations and directions. The communication dated 13/9/2021 issued by the Block Elementary Education Officer is set aside and passed. The respondent authorities are directed not to make any recovery from the petitioner in any mode, including from the retirement dues of the petitioner. The amount of rupees 70,07,1000, which was computed to be excess payment drawn by the petitioner on account of overstay. But during that period, he has got the salary that was sought to be recovered. That was honorable court has set aside that because he has already worked and we have taken the service of the authority has taken the service of the petitioner, so that cannot be recovered. The third direction is important. Below. The respondent authorities are directed to fix the retirement benefit of the petitioner on the basis of petitioner's actual date of superannuation, that is on 31/2018, which is based upon the date of birth as recorded in the HSLC certificate. So the direction is that the retirement benefit is to be fixed as per the date of superannuation, that is 31/2018. Now, my lord, if the prayer of the petitioner is to be considered, then it will be he will get the double benefit. My lord, he has already taken the salary for that period, and honorable court has said that you have overstayed till June 2021. You have got the salary, then that is not to be recovered because you have already, my lord, we have extracted his service. Now he says that arrear pension from the actual date is to be given. Then, my lord, he will get pension for that period and salary for that also. That is not the my lord, direction of the honorable court. Can you see, my lord, the retirement benefit has to be calculated with effect on that date. No, this order is specific.
Yes. That is.
So his pension has to be calculated on the date, this 30/1/2018.
Yes, my lord. Lord. So calculation has to be, my lord, what is to be done here in my respectful submission, Lord. Calculation has to be done considering the actual date of retirement, that is 2018. And, my lord, since he has served and he has got the salary, the pensionary benefit will be released from the date of actual, my lord, when he has left the office. From that day only he will get. But that is what the director has passed. Now he has filed a contempt petition that he has violated the order of the honorable. Because he needs, that is why I have referred to the prayer at page 8. That arrear pension for the period from 1 to 2018 to 36/2021 has to be paid to him. If
that issue has already been decided in this writ petition.
In my respectful submission, that is what I would like to show, Malad. But what is the Malad, this petition has been filed absolutely for that, Malad, claiming the arrear pension for that period, the overstay period. Kindly see page 8. That is the prayer. This is absolutely misconceived.
Oh, my lord, my humble prayer is that, my lord, last order, my lord, this honorable court already has shown the, my lord, mind clear. Even then, my learned friend on behalf of, my lord, this director, contemptuous, my lord, already observed, my lord, this communication, my lord. Even then, this, my lord, kindly, my lord, this contempt may be proceeding may be drawn, my lord.
That communication is before your lordship. I will take your lordship to that communication. That communication, my lord, there is a wrong. There is a wrong because the sentence, the language the director has used, my lord, the director spoke to me. I have, my lord, he came to me, my office, my lord, and I had suggested that the tone and tenor of the letter. This is before your lordship, 27th of September 2024. It is on record.
It is on the record, my lord. It is marked, my lord.
In the contempt, my lord, possibly it has been kept.
This honorable court held that, my lord, this is contemptuous, my lord.
And
marked this, my lord, in the.
I'll take your lordship. One thing.
23rd April.
The 27th of September 2024. 27th of September 2024. The instruction given to the learned counsel by the director bench. But on the last occasion, lordship, the honorable court has queried this, and honorable court said that no, this is not the compliance of the honorable court order. Even I also suggested him that he should have applied his mind while passing this order. But what he said, kindly let me read the order. I would like to inform you that as per Honorable Guwahati Court order dated 25/4/2023 passed in WBC number 1873 of 2023, the office of the undersigned has already finalized the pension case by TPO number so and so dated 11/8/2023.
without making recovery of 17,07,100 for the overstay period with effect from 1 to 2018 to 36 2021 by fixing the retirement benefit, that is the last basic pay of rupees 32,190 on the basis of actual date of retirement, that is 31 2018. This portion he is all right because the direction number 1 and 2 at page 34 he complies. Second part, my lord, as the pensioner has already received the salary for the period from 1 to 2018 to 36 2021, therefore pensionary benefits for the said period as claimed by the petitioner cannot be issued by this directorate. But his language is not correct. But he should have made it clarified that he is obliged to calculate it notionally from the actual date of retirement till the date of release. That thing ought to have come. Well, I have suggested him, he will make it clear. He will make it clear. We'll file an affidavit to that effect. I prefer some time. This portion he ought to have made clear that in notional calculation from the actual date of retirement he has to make and till the date of actual release, that has to be calculated, and whatever is entitled and that has to be clear. I would like to base reliance on this decision. This is a settled, well settled proposition. The period of overstay he has enjoyed salary, he will not enjoy pension again for that period. Area pension, question of area pension doesn't come. Well, this is the case where the person same issue, overstay in service, and ultimately honorable court, while deciding the matter, court has said that you cannot. I'm taking about. Lordship may kindly come to paragraph number 4 is the fact. Just indicating the fact because kindly come to para number 4.
Para number 4
of this decision. The issue, I'm just indicating that issue is clarified. That the notional calculation.
Then they have to file, my lord, appeal, my lord. Because, my lord, showing another, my lord, judgment, my lord, this, my lord, petition, my learned friend submitting.
Let me do one thing. Let my friend.
Another matter, your
Let my
lordship.
friend finish, then I will have to. Let him finish.
Mr. Porvia, let him complete. Yes.
Kindly come to para 4. To actually understand the dispute, the particulars of each of the candidates in WPC number so and so, it is given here it is. In WPC number so and so, Jagadish Kumar Deka, 14 years, 8 months, set on 1st of March 1973. Date of birth recorded in the survey book is 1/9/1959. Corrected date of birth would have been 1/7/1958. So there is difference of 1 year, and ultimately, my lord, kindly come to paragraph number overstay. These are all overstay cases. Para number 5. In the case of the petitioner, while serving in their respective post, the respondent authority informed them that their date of birth were recalculated and were accordingly asked to go on retirement. So far as the petition number 12 is concerned, he was informed that the actual date of birth is being 1/7/1958 and not 1/9/1959, which has recorded in the service book. He should have been retired from service on 36 2018 itself, and accordingly he was directed to go on retirement immediately with effect on 31/12/2013. Thereafter, the petitioner had received the order dated 8/1/2019 issued by the SP Communication Assam, whereby he was informed that there was a proposal to deduct salary drawn by the petitioner for the period of overstay from 36 2018 to 31/12/2018 from the BCRD and the other benefits. That was the order of the authority. And kindly come to paragraph number 18. Ultimately, after considering all the dispute, the honorable court has come to this conclusion. The rival submission variety, the rival submissions of the learned counsel for the parties have been duly considered and the material report is honorable court carefully. From the pleadings and the deliberations, the following dispute fact emerges. The matriculation certificate issued by SEPA admittedly did not contain the date of birth, but the age of the incumbent as of 1st of March of the relevant year. Date of birth of the petitioner were calculated that reduced by the authorities for their matriculation certificate at the time of entry into service. The petitioners were promoted from time to time, and on each occasion the service book was totally scrutinized by the respondent authorities and no anomaly was detected or reported. process of overstay in their service. Then, my lord, kindly come to paragraph number 319, my lord, various decisions have been, my lord, discussed as regard what is to be done in case of overstay. Then kindly come to paragraph number 20. Thus, considering the facts and circumstances and the law laid down by the Honorable Supreme Court, all these laws have been discussed in paragraph number 19. This court is of the opinion that the petitioners cannot be faulted with the chain of events which laid their overstay in service for the reasons cited in paragraph number 18 above. As a consequence thereof, the impugned action in purporting to recover the salaries for the period of overstay, the details of which already recorded in the judgment is interfered with and accordingly set aside. So, deduction is set aside. As regards the claim for pension by following the guidelines of the Honorable Supreme Court in the case of Pandey Jagdishwar Prasad, this Pandey Jagdishwar Prasad is relied in this case also. The petitioners would be entitled for fixation of retirement benefits as on the date of their current date of birth, with a further clause that the period of overstay, that for the period of overstay, only the notional benefit would be entitled to the petitioner's entitlement for salaries for the same period has been upheld. So for the overstay period, only the notional benefit they will entitle. They will not get the amount. So this is where the position has been clarified by the Honorable Court. Now, my lord, writ petition has been filed. Contempt case has been filed first. That if contempt is item number 51, kindly see, my lord. Item number 51, the petition, kindly see. Paragraph specifically what is their case in the contempt case. Kindly see page number 5, paragraph 6, 7, and 8. This will make the what is in the mind of the petitioner. Kindly take up item number 51, contempt case. The contempt petition, paragraph number 6. That in compliance with judgment and order dated 25/4/2023 passed by this Honorable Court in WPC number 187 of 22 and WPC number 4936 of 21, filed by the present petitioner, no recovery was carried out from him for the aforesaid overstay period. But now, the Director of Pension by order dated 11/8/23 granted him monthly pension to the petitioner with effect from 1/7/2021 instead of 1/2/2018. Thus, the petitioner is illegally denied his ADR pension from 1/2/2018 to 36/2021, violating the judgment and order dated 25/4/2023 passed by the Honorable Court. So this is the allegation that we have violated the Honorable Court order. This is the allegation of contempt. Kindly see the next paragraph. That the petitioner begs to state and submit that he is entitled to monthly pension from 1/2/2018 onwards, but he has been granted pension only from 1/7/2021, violating the judgment and order dated 25/4/2023 passed by the Honorable Court in WPC number 187 of 2022. So this is the allegation against us, that we have violated the Honorable Court order. Then kindly come to paragraph number 8. That the petitioner begs to submit that he received salary for the overstay period because of his work rendered in public service, which has no relation with the area due pension of the petitioner, since his actual date of retirement from 1/2/2018 to 36/2021, which has already been clarified and declared by the Honorable Court in the earlier round of writ petition. So now he said that overstay, you have expected my service, so you are liable to pay. You cannot deduct my salary. But Honorable Court has said that I am also entitled for pension, so you give me pension now, area pension. So that is how, in that way, now they want to interpret the Honorable Court order. And in the writ petition, they have sought for a mandamus that we have violated the order, and they have sought for a mandamus at page number 8, that a direction is to be given to release his area pension. That is his claim. That is his case. Page number 8 of the writ petition, that is his case, that why appropriate free order or direction shall not be issued directing the respondents to release the area pension of petitioner from 1/2/2018 to 36/2021 by modifying the order dated 11/8/2023 passed by the director, because by 11/8/2023 the director has given him pension with effect from 1/7/2021. calculating his last pay as
Now,
2008.
now what is your final submission?
My,
You want to file affidavit again?
my final submission, yes, my lord. My lord, that is how the petition lies. This is absolutely misconceived. I'll file an affidavit to that effect. Well, on the face of the materials available before your lordship, my respectful submission is number one. There is no contempt, there is no violation of the honorable court order. And the claim made by the petitioner in this petitioner is absolutely misconceived. Because he has enjoyed the salary for the overstayed period that has been honorable court has upheld that, my lord. He is entitled for that. We are not taking any action. 17 lakhs he has already got. Again, for the same period, how he can claim arrear pension for that he can. Well, the honorable court has in fact third direction clarified that the notional calculation he has done with effect from that has been done. But in the language of the letter, that has not been reflected. It is not reflected. Which is before your lordship, 27th of September 2024. It is not reflected here. It ought to have been.
No, this direction number 3 in page number 34. Paragraph number 20.
Yes.
It is clear.
It is very clear.
And lordship, kindly have a findings of the court, my lord, paragraph 18. ma'am.
Yes.
Paragraph 18.
No,
finding.
maybe there may be some discussion, but the ultimate
Yes,
finding
my lord.
is the page number, paragraph number 20.
Yes, my lord, clearly, my lord, it was provided.
My
ma'am.
lord, I will take, if necessary, kindly come to paragraph 18. I will also take to your lordship to that. Kindly come to page number 33.
Yes.
Page number 33. This is the discussion. Considering the above, this court therefore holds that the respondent authorities cannot make the recovery of the amount of rupees 17,07,100 from the petitioner at the present stage. This court further finds it relevant to take note of another important aspect of the matter, which can be seen from paragraph 30 of the judgment of the Supreme Court in the case of Pandit Jagadeshwar Prasad, wherein it has been observed that the excess amount paid for 2 years to the respondent herein as salary cannot be recovered from the respondent, but while fixing the retirement benefits, the period of 2 years in respect of which the salary was received by the respondent therein cannot be taken into consideration, and the respondent therein would be entitled to fixation of the retirement benefits as on the actual date of superannuation. Paragraph 30 of the said judgment being relevant is reproduced below. Paragraph 30. There is another aspect in this matter. Although we have directed that excess amount paid for 2 years to the respondent as salary cannot be recovered from the respondent, but we make it clear that for fixing the retirement benefit, the period of 2 years in respect of which salary was received by the respondent cannot be taken into consideration, and the respondent would be entitled for fixation of retirement benefits as on the date of superannuation, that is 28/2/2002. In this Pandit Jagadeshwar Prasad, his actual date of retirement is February 2002, but he retired in the year 2004. In the context of calculation of the pension, because there ultimately the last drawn pay, that is the basis for calculation of the pension. The honorable court said that for calculation of pension, the actual date of retirement has to be
taken into account.
That has to be taken into consideration. In the meantime, in this case, my lord, if I am permitted, I will take to the other paragraphs also, my lord. There, my lord, in the meantime, my lord, he got increments for 2 years. He got increments and other benefits. The honorable court has said that should not be taken into consideration. The consideration period has to be the actual date, 2002. Pandit Jagadeshwar Prasad, my lord, the person retired in 2004. He overstayed 2 years. In that context, this paragraph has been put. Therefore, ultimately the paragraph 3, the direction number 3 came. That the retirement benefit of the petitioner on the basis of petitioner's actual date of superannuation, that is 31/2018, which is based upon the date of birth as recorded in the HSLC certificate. That has to be considered. We have considered that. The notional calculation part, the authority, he has to clarify that the notional thing he has calculated, and in fact in the order, in the order, it is clarified that the last pay drawn as on 31/2018 has been considered and he has been released the pension. That has been verified. I'll bring these things, my lord, in the form of affidavit, if it's necessary. Otherwise, my lord, thing is very clear. On the materials available before our lordship, it is clear. I'll bring it.
No, the question is, can it be said that there is any willful disobedience of the order of the court?
Yes, my lord.
How?
Because, my lord, my learned friend, my lord, how, my lord, taking the respondent under the danger zone before this honorable court, my lord, already condemned. This is not in the writ petition, my lord. Earlier occasion, this honorable court wanted to promote or take the contempt. Then I said, my lord, already contempt petition is so and so item, my lord. Therefore, it is also tagged with item number 51, my lord. And, my lord, this kind of, my lord, submission, it is, my lord, afterthought and full conscious mind, my lord, they are submitting, my lord, against the specific judgment of this honorable court, my lord. Therefore, my lord, earlier occasion,
No,
this honor.
Mr. Borpunya, this going by the paragraph number 3, can it be said?
Yes, my lord, exactly, my lord, because it is Supreme Court and our court, my lord, already cleared that, my lord, it is, he worked, my lord, therefore he got some, my lord, remuneration, my lord, wages
No,
like.
that has been dealt with in this
Yes, my lord. Now, my lord,
no, this point number 2.
Yes, my lord.
So there is specific direction that the said amount should not be recovered.
Recovered, my lord. And, my lord, my actual date of retirement, it is also given, my lord. That should be, my lord, given my pension from the actual date of retirement, my lord. But he is arguing, my lord, but and communicating that, my lord. No, sir, a salary is given, you should not be given, my lord, pension. You should be given pension from, my lord, when, my lord, you till your overstay period, my lord. But here in the
No, this paragraph, no, this point number 3, it is clear.
Yes, my lord. The respondent
Retirement
authority are directed to fix the retirement benefit of the petitioner on the basis of the petitioner actual date of superannuation, my lord. So, my lord, my date of pension should be counted from actual date of retirement, my lord. Otherwise, some problem will also arise, my lord. My increment, then my fixation, my regularization of these 3 years, etc., etc. Come in this regard, another judgment is also there. Therefore, my lord, this honorable court considering everything, my lord, to cut short, my lord, it is clearly given, my lord, that my pension should be given from the 31/2018, my lord. But he is arguing before your lordship, no, my pension should be given from the, my lord, 2021, my lord, July 2021, my lord. This is, my lord, contempt. This honorable court given him chance, my lord. Earlier occasion, lordship kindly have a look the language of the this honorable court in the earlier interim order. And it was provided that, my lord, court is not satisfied. It is contemptuous, my lord. Therefore, thereafter, my lord, again, my lord, he instructed, my lord, and my learned friend is arguing before this honorable court. No, it is given as per order of this honorable court, my lord.
Proceeding, kindly come to the direction number 4 also. 4. This is also important. He is also referring to this. The respondent authorities, including the after 3, respondent number 3, including the elementary education department and the director of pension, are directed to immediately process the pension of the petitioner so that the petitioner receives his arrear pension as well as all other pensionary benefits at the earliest. This is the direction. The said exercise be completed within 4 months. But this order was passed on 25/4/2023. And his date of actual release from service is July 2021. 21 to 23, but 2 years period is already there. Therefore, honorable court directed that you release the immediately pension and other arrear pension and pensionary benefit within 4 weeks. So we have to understood in that context, not the arrear pension from 18 to 21. That period he has already enjoyed salary, double benefit he cannot.
Yes, my lordship. Recently, one case, my case taken, your lordship, my lord, I filed same content, my lord, and my learned friend, my lord, Chisti was there, my lord, and he shown, my lord, all the arrear pension is given. Therefore, contempt was closed, my lord. And this order is also, my lord, I communicated with learned my friend, my lord, Deuri also, my lord.
Okay, let them file. Yes. We'll let our stand be proper. Otherwise, I have shown, my lord, that
if they are not satisfied this order, my lord, they simply ought to have, my lord, file appeal, my lord, showing all this ground, my lord. And, my lord, this honorable court already given them chance, my lord. Your lordship observed this is right, my lord, that may not be willful, my lord, violation. But when they, after giving the chance, my lord, showing mind of this court that, my lord, this, my lord, it is contemptuous, my lord, their stand is. Even then, they are, my lord, arguing before your lordship that this is not done as per order of this. But order is very clear, my lord.
We have complied with the order. So there is no
Heard,
question of
heard,
filing it.
Mr. A. Porboya, learned counsel for the petitioner. Mr. D.M. Nath, learned senior government advocate for the
For respondent,
respondent number 4. Respondent number 4, Mr. David Bond.
we have two.
Okay. And Mr. Peggy for limited part. So Solia is there? Yes, number 2 and 8. Heard in court. Place the matter on when
Give us, let it be after 2 weeks, no, intimate.
after 2 weeks. In the meantime, Mr. D.M. Nath, learned counsel, State counsel, no, learned senior government advocate for the respondent number 4. They filed additional affidavit.
My lord, this matter may be taken up along item of 51, my lord.
We have not filed the affidavit earlier. For the
Not
first
filed.
affidavit in opposition for the first.
Okay, to file an affidavit in opposition. This matter shall be taken with a contempt case number 130 of 20.
Item of 51, my lord. Obliged, my lord.
Production list for motion item 1.
May please, Lordship. Lordship, petitioner herein is working as assistant teacher in LP school, Lordship. Subsequently, Lordship, under Samagara Shiksha Abhiyan, he was also appointed as cluster resource coordinator, Lordship, at page number 15 of my writ petition.
Yeah.
It was not served to me. And it was, and 2:30 it was informed that I enlisted will move unlisted.
But is that a order?
At page, kindly come to page number 15, Lordship. In the greater interest of academic upliftment of elementary education of the district for smooth conduct of SSA activities, following teachers are hereby attached as CRCC inserts in the cluster mentioned against their name with immediate effect. Lordship, my name is serial number 2, Lordship, Nobin Chandra Sharma. He was working as assistant teacher in Sati Hamuka LP school, and he was appointed as CRC insert at Kolovanga cluster, Lordship, in Rupsi block, Lordship. While he was working as CRCC, Lordship, on 22nd of January 2025, Lordship, the district commissioner of the Borpeta district, Lordship, suddenly visited the LP school where the petitioner was working as assistant teacher and found him to be absent in that school, Lordship. The district commissioner also saw that in the midday meal, half of an egg was given to each student instead of one full egg, Lordship. And thereafter, because the petitioner was absent on the school, Lordship, he was called to the office of the deputy commissioner and he was asked as to why he was absent. Then he explained that he was attending a meeting of a cluster, Lordship, that is at page number 18, Lordship. This was the BACC meeting for the month of January.
Where is the date fixed that today is the last date?
Lordship, at page number 22, Lordship. This is the impugned order, Lordship. In the interest of quality education of elementary school, the following cluster resource center coordinator hereby transferred and mentioned below. The concerned cluster resource center coordinator are directed to clear their liabilities in the present cluster and obtain NOC from BMO concerned and thereafter join in newly allocated cluster within 7 days. So it was passed on 6th of March, Lordship. So 6th and March, 7 days. Today is the last date, Lordship. He was absent because he was attending a meeting. He was on duty, Lordship. As CRCC in charge, he was doing that duty, Lordship. So he was absent in that school, Lordship, where he was working as assistant teacher. The meeting was held on 22nd of January, Lordship, at page number 18, Lordship, of my writ petition, Lordship. The BACG meeting for the month of January, date 22nd of January 2025. My name is at page number 27, Lordship. I was attending the meeting, Lordship.
No, whether on account of this, you have been transferred.
Lordship, so it is a transfer order in disguise, Lordship. Because of that fact only, I have been transferred because when I was called to the district commissioner office, Lordship.
Going by the impugn order, can it be said that on
that
account
is
of
not
remaining
there,
absent
Lordship.
in school, you have been transferred?
No, that is not there, Lordship.
Then-
It is a order in disguise, Lordship.
Mr. Bora?
It is in public interest, though public interest order is not
Immediate-
there. It is in the interest of quality education. That's why it's the intent of service. He is only shifting from, in the same district, he is being shifting. One block to another block, one cluster to another cluster. In the same district itself, madam. And block is also same. Rupsi.
But that is around 42 kilometers away from my home, Lordship. And I have at paragraph number 12, I have stated, Lordship, I have a 11 years daughter, Lordship. She is suffering for G6PD deficiency. G6PD is an enzyme, Lordship, that protect the red blood cells from damage, Lordship. She otherwise she is okay, but sometimes because of this disease, Lordship, she get faint and she need immediate medical treatment, Lordship. If now this petitioner is transferred to the new cluster, Lordship, it will be around
Okay, Mr. Bora,
Also with a petition before the concerned managing director, my lord, of the SSA. We will take care of it, my lord, if the treating the regions of his difficulty.
whether you have filed any such
no,
application?
Lord.
You will file fresh one, my lord.
Lordship, then I may be permitted to file the representation, but till then, Lordship, no this transfer order to be state, Lordship. Till that date, a decision is taken on my representation.
My lord. Let him file affidavit, let him
When
file
the-
the
this is the-
representation, till then.
Today is the last
Problem
date,
is
Lordship.
that there is a limited scope for interfering with the transfer order
That is correct.
by exercising lead jurisdiction.
Let me file the represent. Till then, this transfer order to be disposed of, state, Lordship.
But that will
I'll
create
file
another
the-
difficulty, my lord. That will create another difficulty. Let him file a representation, that will be disposed of within a week, my lord. But you can direct it.
Till then, no effect shall be given to this order.
Yes, Lordship.
That is the- Then lordship will that representation before the, he will file a representation immediately
Within a week,
within a week.
and
representation
after
will be-
another week, this
Lordship.
shall be disposed of.
Lord.
Heard Mr.
AD Chaudhary.
Eddie Soduri, learned counsel for the petitioner, and also heard Mr. Bora, learned standing counsel for the SS.
SSH.
SSA. In this petition under Article 226 of the Constitution of India, the petitioner has tried for the petitioner has challenged the order dated order number SSA stroke DTT stroke double P stroke CRCC stroke PT Roman 3 stroke 415 stroke 2024 stroke 1362 plus A dated 60/2025 passed by the additional district commissioner cum district mission coordinator SS Porpeta. It is to be noted here that by the impugn order dated so and so the petitioner is transferred from Kalabanga Cluster Resource Center to Roha CRC. Roha CRC. Learned counsel for the petitioner submits that this impugn order is punitive in nature, and that on 22nd of January 2025, he was attending one EACG meeting at Rupsi Kalgasia, and on account of the same, he remained absent in his school. And on visiting his school, he was found absent by who visited your school?
District Commissioner.
District Commissioner, Deputy Commissioner.
Yes, sir.
Now it is district. Now it is renamed as district.
District Commissioner. District Commissioner. And having found him absent in the school, this transfer impugn order was passed. Mr. Soduri further submits that though the concerned school is within the same block, yet the distance between the two schools is 40. What is the distance?
Block office is 42 kilometer away, Lordship.
42 kilometer away from his from the present school, and that he has a daughter who is suffering from
G6PD deficiency.
G6PD deficiency, and she often required medical treatment. And in the event of his transfer to the aforementioned school, he will not be able to attend his daughter, and therefore Mr. Soduri has contended to stay the impugn order. Mr. Gora, learned standing counsel for the SSA, submits that the petitioner may be directed to file on representation before the
Respondent number 3, Lord.
respondent number 3. Respondent number 3. And further, respondent number 3 may be directed to dispose of the petition within a period of 1 week from the date of receipt of the representation. The learned counsel for the petitioner further submits that till disposal of his representation, the order, impugn order may not be given effect. To which Mr. Bora submits that he has no objection in the event of passing such an order. But having heard the submission of learned counsel for both the parties, it is provided that now this court is inclined to dispose of this petition by directing the petitioner to file on representation before the respondent number 3 within a period of 1 week from today. And on receipt of the same within a period of 1 week, the respondent number 3 shall pass an order affording an opportunity of being heard to the petitioner. In terms of above, this petition stands closed.
Till then,
Rest of the matters that may be taken.
Till then, Lordship, this order not to be given effect. Lord.
Till then, the impugn order shall not be given effect.
In respect of the petitioner, there are two petitioners there. There are two persons whose name is there. Is in respect of the petition now.
Okay, in respect of the present petition.
Item number 18, can it be on 27? Item number 8.
Item number 48, matter, it is a
On
part hard
27.
matter, let it come on 19. March
19.
Item 32.
Take a date from him.
This, my again is 35. Item number 48. 48, it's a part hard matter, my lord. Let it
Yes,
come
all
on-
right. I have remembered it.
Yeah.
We will keep the matter parted
Yes, yes.
on 19.
19. On the top, if possible, on the top of the admission, my lord. Otherwise, argument was already almost completed.
Apologize, Manan.
As a top of the list.
48.
Item number 32 also pardon, my lord. 32.
Apologies, my lord, item number 29 is a bail hearing matter, my lord, next week, my lord.
CT not available. In the morning hours, you could have tell the court. You could have informed the court.
I was.
When you will be able to produce the case. Karimgঞ্জ. Case diary or it is searched case?
Yes, it's charged. Remanded from Supreme Court, my lord, the matter.
Then scan copy of the
Scan
record.
copy. Yes, a scan copy was called for.
Okay. Mr. Dekha.
Dada.
Mr. KK Das learned additional 50 submits that the scan copy of the record has not yet been received. And press for fixing another date. Here is allowed. Let's list the matter on Wednesday.
Thursday, my lord, next Thursday.
Thursday. Okay. Rest is a reminder to the learned trial court for transmitting the record to the order date.
Much obliged, my lord. Happy Holi, my lord.